This matter is pertaining to civil case number 4, madam. Lordship, 11, madam. I don't know. Non-payment of contractual bill, madam.
Okay. Item 11. It's supposed to be a bench for matter. So the registry shall examine and place it before the appropriate bench.
Please, Your Lordship. Lordship, consider the other side. I beg to mention item number 44 and 45, Your Lordship. In this matter, draft affidavit is ready, but the signing authority, the SC, is on sick leave, Your Lordship. May I pay a week's time, Your Lordship? We'll file the affidavit.
You've informed the other side?
Yes, Your Lordship.
I'm for a petition, madam.
Lordship, can it be on 15th of May, Lordship?
Okay. List on 15/5/2024 as paid for by Mr. R. Owen and it's standing also for the
Excise Department, Lordship.
Excise Department.
Excise. How will I do it?
Well, there is an interim order that may be called.
Okay. Interim order passed today stands extended.
How will I do it?
May it please, Your Lordship.
Yes.
With due consent from the other side, I'd like to mention item number 34 of this daily list. I've taken consent from the other side. I'd like to file a rejoinder to the affidavit of position filed by the respondents. 2 weeks time may be granted.
This item
Item number 34.
34. Okay. 2 weeks.
2 weeks, Your Lordship.
Okay.
The matter may be taken up on 7th of May.
7th, we are not facing 8th or 10th.
8th, Your Lordship.
List on 8/5/2024. As paid for by learned counsel for the petitioner so as to enable him to file affidavit in reply.
Interim order may continue.
Interim order passed today stands extended to the next date of listing.
May I please, Your Lordship, with the consent of the other side, I beg to mention item 28. Our affidavit is here, Lordship. Some type copies will have to be prepared, which is why we'll file it tomorrow, Lordship. Matter may be adjourned for 3 weeks, Lordship.
Okay, you have taken consent of the other side. What says the represented? On the prayer made by the standing counsel for the Forest Department. List after 2 weeks, 3 weeks, so as to enable him to file affidavit in opposition in the matter. Yes.
May I please, Your Lordship? Lordship, I have taken the consent of the other side, Your Lordship. I beg to mention item number 41, Your Lordship. I am on behalf of MS S. Roy, Your Lordship. Matter may be adjourned for the day, Your Lordship.
Item
41, Your Lordship.
41. Okay, also is represented on the prayer made by counsel for the petitioner. The matter is adjourned today. List after
Lordship, after 2 weeks.
2 weeks.
Please, Lordship.
Let's leave, Lordship.
Yes.
So, like to mention for item number 51, madam. I have taken the consent of other side private respondent, madam. Then matter may be passed out for the day only.
81 white has come.
Well, it's for orders, madam.
No, that I understand. It's in the orders column, so it has come for orders.
Well, substituted petition already filed, madam. Original petition is expired, madam.
Okay, on the prayer made by counsel for the petitioner. Matter is adjourned today. List after 2 weeks.
Next week, madam. Next week, any day.
May I please, Your Lordship? Lordship, I beg to mention item number 12, Lordship. Actually, Lordship, similar matter is fixed on next Friday, Lordship. That is a WPC number 214, Lordship.
I'm just adjourning it. You're not seeing.
Lordship, similar matter, Lordship.
At motion, I'm not fixing, I'm not tagging any matters in motion time.
Both are the similar matter. Your Lordship fix it on last Monday. Your Lordship fixed that matter on next Friday.
It's okay, whatever you see, in one order, one case, whatever order is passed will follow in the other cases. In motion, I'm not tagging. Even if it is same. Even if it is same between the same parties, same petitioners, still it's a motion matter. List in next week as paid for by and counsel to the petition.
With regard to item number 27 of today's matter, The petition has become infructuous, madam.
27.
27. The order which was challenged has been withdrawn by the government.
Okay. All sides are represented. Mr. B. Prasad, then counsel for the petitioner, upon instructions, has submitted that the order in the challenge has been withdrawn by the state government
While order dated 27/9/2022.
by order dated 27/9/2022. So accordingly, as per his instruction, the matter has become infructuous. So accordingly, the matter stands closed, having been rendered infructuous.
Okay.
Daily list, item 1 for motion.
Please, Your Lordship.
What is the date of the order?
This is 24/5/23, my lord.
Contact. The pendency shall not be a bar for compliance of the order. Yes, I shall not be constable the petitioner.
Deeply obliged.
Item 2,
Order dated 24/5/23.
24,
5/23.
24, 523. Okay, same. Your name?
GRA Muttaqi.
GRA Muttar. Pendency shall not be a bar. Okay.
item 3,
Yes, you have got information.
Okay.
You have
So
got
in this matter, we have been asked to take instruction as regards action that has been taken in response to the FIR.
Yes,
Already the final report has been submitted here. We have it in the form of a parawise comment, but
it's okay. It's okay. Once you see that charge sheet has been submitted.
yes,
So
yes.
okay, we close this matter then. But Mr. JUNM Taskar, General Counsel for the petitioner. On the ground that there's no progress in the investigation of Karimganj PS case number 1099 of 2017. The present petition has been filed under Article 226 of the Constitution of India. Next slide. Mr. S. Barwal, and a government advocate, has produced a copy of instructions dated 17/4/2024, received from the Superintendent of Police, Karimganj, wherein it is stated that the investigation of Karimganj PS case number 1099 of 2017 under section 306 IPC has been completed, and a final report bearing number 451 of the 17 dated 31/12/2017 has already been submitted. Pushpa. Next, in view of such disclosure, this petition has become infructuous, so accordingly, the petition stands closed at the motion stage with the issuance of notice on the respondents. The copy of instructions. This is a copy of the instructions produced kept as a part of it.
Item 4,
This is not RTA, related to RTA Act. I am petitioning person.
Yes, yes.
That my original application dated Lordship 25/4/2022. I saw 9 information from the public information of the Nomoligo refinery. The public information officer informed me why
I'm issuing a
later it
notice.
is
I'm issuing a notice.
Lordship.
So this is, you are appearing as CEC?
Lordship, I served a copy as per
He's
the
appearing as CEC, Mr. Barwa, no. We asked last time
Lordship.
to appear for the commission.
Yes.
You have been served with a copy.
Saha.
You have any instructions? No.
SS Roy appeared.
That's Roy was appeared. I can inform him. Let's see. Brief is not with me.
In
Okay,
person.
then we issue a notice then.
Lots.
For Mr. N.M. Hazarika, petitioning person. Also heard as Barwa on the CEC appearing for the respondents. Sorry, respondent number 1.
Yes, Lord. SS Roy. No copy service.
Everything non-furnishing of requisite information in the RTI Act. The present date petition has been filed under Article 226 of the Constitution of India. If notice returnable in 4 weeks. Requisite extra copy of the petition be served on the learned CEC in course of the day. Petitioners expect within 2 days for service of notice on the respondent numbers 2 and 3 by registered post with AD. Next paragraph. Pendency of this petition shall not be a bar for providing the information as required. On this after 4 weeks.
Name of the deputy SCI may be shown in the cause list.
Oh, okay.
Deputy SCI not shown. in the-
Okay. The
SCI
name of
not-
DSGI oblique CCC shall be repeated in the cause list while listing the matter next.
Published.
item 5,
Yes.
May it please your lordship. Let the some constructions were made in my
I'll issue a notice.
encroaching upon.
I'll issue a notice here
Yes, the notice should go. Let them respond to it.
for Mr. KK Mohantal and Senior Counsel assisted by Mr. M. Saikia, Counsel for the petitioner. Alleging illegal constructions and refusal to remove garbage, debris. And non-compliance of the order in appeal dated 18/1/2024. The present writ petition has been filed under Article 226 of the Constitution of India.
18-1 really?
You are appearing for who's for GMC
As Bora's name may be recorded.
as well. Mr. S. Bora, then standing also for respondent numbers 1 and 2. Mr. S. Bhagwan and Government Advocate appearing
356.
for respondent numbers
3,
4,
5,
3, 5,
6.
6,
4.
and
IPF 4.
Mr.
4.
A. Bhattacharya doesn't. Standing counsel for the respondent number 4 accepts notice on behalf of respondent numbers 1 and 6, 1 to 6. Mr. Requisite extra copies of the writ petition will be served on them in course of the day. Next, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 7 to 10 by registered post with AD. Next, the counsel for the petitioner is at liberty to correct the postal receipt number and to submit postal track report prior to the next date of the same. Next para. The pendency of this writ petition shall not be a bar for the authorities in the GMC to look into the grievances of the petitioner. List after 4 weeks. Not to become 4 weeks.
Item 6, 7, and 8.
But in item number 6, 7, and 8, Malad. So in 7 we have filed the affidavit, Malad. And in item number 6 and 8, I have received the instructions yesterday. Kindly give me take it up on Monday or Tuesday. Malad. I'll file the affidavit in the meantime.
It's a question of security.
It's a question of security, Malad. The SSRC has taken a decision on 27th of March, Malad. In fact, against the petitioner of Malad, item number 8. My instruction says there are 4 criminal cases in one of case. There are 4 criminal cases registered against him. And I have the instructions.
Because they need protection.
That is why they need protection. Yesterday only, my lord.
No, he is involved.
No, I
My lord,
understand.
my lord, let me, before my lord, jumping over, my lord.
Someone, you remember that what you call Uttar Pradesh case?
My lord.
What was that name? A criminal whose car flipped and he died.
Right, don't remember.
My lord,
Only thing, my lord,
my lord,
because I have a right to start my pleadings.
yes.
8 has connected with item number 55. What my friend's instruction is waiting, it is there in 55. They have issued a letter to withdraw my PSO.
Exactly. If you have 4 criminal cases, why you need a PSO? You
My
are-
lord, the criminal cases I have filed against the others.
Huh?
But they are saying but the criminal cases I have annexed. These are my criminal cases I have filed against the others.
Which item?
55.
55.
It is interlinked with 8.
55.
Yesterday only in Ganeshguri there was a shootout, my lord. Yesterday only there is in Ganeshguri there was a shootout. Somebody has died, man. Page 24, your lordship will find.
Page
24. The impugn order is at page 41. No reason shown in the impugn order why the PSO, which was there up to from 21 to 24, suddenly withdrawn on my lord 18/4/24. Page 41. The horizontal page, my lord.
just a minute.
Page must be ঠিক আছে। And page 25, where my lord,
Just a minute. Page number?
my lord, page 25, your lordship will find where I was provided with a PSO on payment basis. And my lord, now the impugn order is at page 41. The order reflects nothing, my lord. No reason shown. Please withdraw close the existing PSO provided to such and such from your end and confirm action taken by us. There's no reason shown why they have withdrawn. And my lord, till 24 March,
That will be in the review committee meeting, decision.
my lord, 27/3, if there is a review committee meeting, for 1 month, they cannot disclose the reason, my lord.
We'll have
27/3.
to give them time. So
And
it
my
will
lord,
be-
my lord, the criminal cases, what my friend has stated, these are, I have filed against the others, my lord.
Where is that?
My lord, first of all, it starts with page 24, then my lord at page 26.
Just one, just now. Yes.
My lord, page 24, then 26, then 28. These are all my cases I have filed against others. No criminal cases are pending against me. I have filed these criminal cases against others. Page 28, your lordship will find received and registered in 21 such and such. We investigate the case. It was filed by me.
Okay, but still we'll have to give them time to file their.
Malad, I have got the instruction. I just want to bring show one point, Malad. Kindly have my instruction, Malad. I have given the copy, Malad. Kindly see paragraph 11. I got the instruction yesterday, Malad. Kindly see the next page, para 11, Malad. Para 4 and para 7 also, Malad. The Nurmati PS case, it is already FR has been filed on 36/2021. Para 4.
And page
Para 7. And para 11, kindly see, Malad.
Next, next.
And para 18, Manok. Para 18. Hajo PS already FR filed on 31/7/23. He's showing two cases, one Nurmati case, one Hajo case. All our FR has been submitted in both the cases. And para 11, I have I have seen, Malad. Lordship, may kindly see, Malad. Lordship, kindly give me 1 week time, Malad. I'll file the affidavit by Monday, Malad. Today is Wednesday, Malad. By Monday, I'll file.
Can I pray for an order of a status quo?
No. With these instructions, no.
Yeah, my lord, I'm representing item number 6.
Just one by one.
My life is, my lord, very danger now. I have annexed some documents also. And without my lord saying they have.
Just a moment, one by one. I can't hear two matters together. Item 55 and 8.
Please,
What Mr. Speaker also be on counsel for the petitioner. The agreed by the withdrawal of personal security officer, even like a PSO. The present petition has been filed by the Article 226 of the Constitution of India. And I think that there is a life threat to the petitioner. Mr. D. Nath, Senior Government Advocate, accepts notice on behalf of all the respondents.
Malad, Lordship.
All
In-
the respondents. So requested extra copies of the application be served on them in the course of the day. Next one. The learned additional senior government advocate has submitted that he has received part of his comments. That communication dated 23/4/2024 and place for time till 29/4/2024 to file affidavit in opposition in the matter. Very well out. That the affidavit in opposition be filed by 29/4/2024. List on 1/5/2024. The notice including notice on the pair of action to give.
Malad.
We are returning to this.
Yes, Lordship has given a tip.
One, you filed by 29th, we are
By
taking up on first
Lordship.
motion.
Lordship.
Sorry, admission.
Malad.
Eight. Yes. It, item 6.
In item 6 also, Malad, I have received the instructions. Malad, here, Malad, fresh assessment has been done on 18/3/24. Malad. I have. Malad, here also, Malad, I pray for some time. Malad, let me file the affidavit.
My lord, here, my lord, what happened, my lord? There is a, my lord, several attempt was from there, from the hooligans, my lord. I have annexed the photograph as well as the affair also. Suddenly, my lord, without any authority, opportunity, my lord, on 31st, my lord, my security was withdrawn.
So the SSRC meeting was held on 27th of March, Malad.
And
And-
in persons to the
and-
direction, my lord.
Yes.
And in persons to the direction, my lord, that your lordship will see at page, my lord, operative part at page 76, my lord. Para 8 and 9.
When did you hold a meeting?
27/3/2023 is the SSRC meeting. And in respect of this petitioner, again, the, not, my instruction is that
Just give me the date again,
27th of March 2024. The SSRC meeting,
SS,
the state level, State Security Review Committee,
SSLC,
SSRC
RC,
Review Committee,
Okay.
State Security Review Committee.
for the petitioner when it was held.
And again, my lord, the SP Kamrup and the IGP CWR dated latest state assessment has been done on 18/3/2024. Well, I'll bring it on record, my lord, by filing the affidavit. Kindly give me 1 week time, my lord. By Monday, I'll file. My lord.
My lord, by this time, my lord, on the last occasion, my lord, they have, by this time I'll be eliminated. Lordship has seen, my lord, FIR
We
and
can't help
photographs
it.
also.
We can't help it.
And my lord, I have given in persons to the direction of the honorable court, my lord, I have approached, I have given 2 representation, my lord, without providing any information, my lord, and my security was withdrawn, my lord.
We need to wait till.
And
Monday,
moreover, my
till
lord,
first.
I am election camping is going on, my lord. I am the minority cell, my lord, in given
Till
direction.
first you'll have to wait.
So can it be a very short date, my lord?
Sydney, one day, 1st of May,
Yes, sir.
29th, they will file their affidavit.
Yes, sir. File.
By 29th,
But
you'll be
in
filing.
case they do not file, my lord, lordship will pass the interim order. That
He's
observation,
assuring us.
that observation be
assuring
given.
us.
Otherwise, my lord, I,
Same order. Mr. J. called me. Notice including notice on the prayer for interim development. 29th and 1st. Give him extra copies.
Yes.
Possibly. 7th,
lordship are fixing all together on same. my lord.
7th also same.
No, no.
Lordship, I appear for
Seven,
petition
my lord,
item
we have,
number 7, your
we have
lordship.
filed the affidavit. My lord.
Lordship, we
Here
received an affidavit in opposition yesterday, your lordship. We require some time to file a reply, your lordship. May I put a matter may come up on 6th, your lordship? 6th of May.
Let it come on first. We are having all this. matters
Lordship,
together.
we will require some time, your lordship. Was a meet second, so on 6th, your lordship.
Uh, Mr. Adam Tekalan, counsel for the petitioner. A place for. And is granted time to file affidavit in reply in the matter. Mr. T. Leonard, senior government advocate is present. And submits that affidavit in opposition has already been filed yesterday.
Yes, sir, lord.
Registry shall tag the same on record. Next. As notice has already been issued by order dated 3/4/2024. Published in the admission column on 6/5/2024.
Lordship, if I may, lordship, the status quo, your lordship, interim order in place.
Okay, interim order passed to this stands extended to the next date of listing.
Lordship.
Hold on.
This matter will be segregated. And this listed on listed on stands. Item 9.
Please, lordship.
No, in Lanka, this municipal board, who's appearing for Lanka Municipal Board?
There's no standing council.
No. You see, in this case, we have dealt with the matter many times. There are several writ petitions pending for allotment of rooms against
The Vitas.
Vitas. And there are multiple orders and
I
then
remember. Because they have been continuing and some of them.
you see, some point of time, somebody is coming and the allotment is, that is,
Once I also
state.
dealt with those cases, I remember that.
so we are having some difficulty in progress because in one or the other case, there is a stay order operating and the authorities are unable to take a decision on those rooms. How many rooms are there? 200 plus.
200 plus.
How many applicants are there? 300 plus. I get the point.
Since we have got the pattas earlier. Lordship.
No, that's okay, but this is something we can't do anything about it. Who's the, do you remember the name of the council who's appearing for Lanka Municipal Board? In other cases,
I didn't remember, Lordship.
you just give us call of, for advocate for Lanka Municipal Board. Advocate for Lanka Municipal Board. We'll take it out after some time. Let the council come.
Lordship.
You also try to find out.
Lordship.
Item 10.
May it please your worship. Incident was took place at emergency cabin of Ham Hospital on 10/3/24 when the petitioner
Just a moment, just a moment. Yes, Mr. Barwa.
Yes. Already the matter is before the Child Welfare Committee and the custody has been taken out. Now their grievance is that FIR has to be acted upon as they wish. Because this sections appropriate and non-bailable, so this is their prayer. So obviously, based on the investigation, the charge sheet will be framed. At the moment,
But
the
then you'll
petition,
have to go to, then you'll have to go to the jurisdictional court and then make a prayer.
yes.
Yes, my lord, we have already prayed.
Where is that?
My lord, page number 34, annexure G.
34.
Yes.
No, jurisdictional magistrate, we are saying, 156. 3, it gives jurisdiction to the magistrate to take up the matter.
Yes.
If the SP, letter to the SP is not working, you'll have to go to that. You'll have to follow Sakiri Vasu.
156(3).
My prayer is for free and fair investigation.
You see, there is a forum established for that only. You have to go to the chief judicial magistrate and make a prayer.
156.
Every case we can't handle in the High Court. We don't have jurisdiction.
Worship, we have given an application before the respondent number 3 also,
Who is respondent number 3?
Superintendent of Police only.
Oh, we have seen that. We are closing this, we give you liberty to go to the jurisdictional magistrate. Your name?
Amy Borbi.
Mr. M. Borbuyal and counsel for the petitioner. And Mr. S. Barwar and the government advocate appearing for the respondent numbers 1, 2, and 3.
Yes.
1, 2, 3, 4.
1, 2, 3, 4.
The case of the petitioner is that he had taken his minor son in the emergency cabin of HAMM Hospital, Hojai. As his son was, as his minor son, aged 17 years, was suffering from stomach pain and appendicitis. Full stop. It is projected that the attending doctor, who is read as respondent number 6, had asked him to speak in Hindi, which he could not, and therefore he was assaulted by the doctor. Full stop. In respect to the said incident, an FIR was lodged by the petitioner, which was registered as Hojai PS case number 76 of 2024. It is alleged that the case was registered at available sections, and resultantly the doctor within bracket respondent number 6 got bail. The issue was taken up by the Child Welfare Committee of Hojai district. Correct?
Yes.
Who had recorded the statement of the victim and declared the child as
Need care and protection.
what is full form of
Need care.
ENCP? What is that?
Need care and protection. Need care and
Child in care of need and protection. Within bracket CNCP. And the officer in charge of Hojai police station was directed to investigate the matter. Alleging that proper investigation was not carried out, the petitioner has submitted a representation to the Superintendent of Police, Hojai, on 11/3/2024, which has not been acted upon. Hence, this repetition for a direction to the Superintendent of Police, Hojai, and or state CID to initiate proper and fair investigation. Next paragraph. Next one. In such matters, the Supreme Court of India in the case of Sakiri Vasu versus State of Uttar Pradesh and others, 2008 to SEC 409. Has inter held that an aggrieved person can only claim that the offense he alleges be investigated properly, but he has no right to claim that it be investigated by any particular agency of his choice. Even if an FIR has been registered and police has made the investigation, which the aggrieved person feels is not proper, such a person can approach the Superintendent of Police under Section 154 within bracket 3 CRPC, which the petitioner has done. And even if that does not yield any satisfactory action, the aggrieved person can approach the magistrate under Section 156 within bracket 3 CRPC. First of all, it has also been provided therein that if the magistrate is satisfied, he can order a proper investigation and take other suitable steps and pass such orders as the learned magistrate thinks necessary for ensuring a proper investigation. In light of this decision, without expressing any opinion, the court is inclined to close this petition by granting liberty to the petitioner to approach the jurisdictional magistrate under Section 156 within bracket 3 CRPC. As the magistrate is empowered to direct the officer in charge of the concerned police station to hold a proper investigation and take such necessary steps as may be necessary for ensuring a proper investigation, including monitoring the same. First of all, with the observations as with the liberty is granted above, this petition stands closed.
Item 13.
Just yes, here again, this you have got instructions. Again, this there is a motorcycle which is identified. You will to take instructions because we can't
Yes.
postpone it. For last week
we are
were
writing.
adjourning.
We are writing to the department. And one thing I have may submit. There is a judgment of the Supreme Court in Reliance versus Shashi Sharma. It's a case of motor vehicle accident where the insurance company went into appeal There, what happened, my lord? This is reported in 2016,
Just,
9 SCC.
just a moment. Yes, page.
Page 627. Reliance General Insurance Company Limited versus Shashi Sharma
Just
and
a
others.
moment. Not opening. Please give the citation again, 2000.
2016,
Yes,
9 SCC,
yes.
627. Mail of yes. Mail this. I've sent the citation in the mail also.
Yes, we got it.
In paragraph 26,
Dependents cannot maintain claim for both.
yes,
So that's
because
why
they
we
are getting, yes, they're getting
you see,
under,
that's why we are
one
asking
scheme.
you to tell us to take an appropriate stand.
yes, yes. Day before yesterday, Lordship has issued notice in one of the, we have written letters to them.
You take instruction, file an
Yes.
affidavit, we are issuing a notice then.
Fine.
You file an affidavit. So these issues, if we are postponing, we are multiplying cases here. But Mr. SI, I can counsel for the petitioner. Claiming ex gratia on account of death of the account of death of the husband of the petitioner in a road accident involving motorcycle bearing registration number TS 15E 0801. The present petition has been filed under Article 226 of the Constitution of India. Mr. Abe Bhattacharjee Leonard, standing counsel for the Revenue Department, representing respondent number 1 and 2.
1.
2 also. 2 is finance.
Finance.
For finance, you are not taking.
She is there.
Okay. For the Revenue Department, from respondent number 1. Ms. R.
RM Barra, Your
R.
Lordship.
Barwa, Leonard, standing counsel for the Finance Department, representing respondent number 2. And Mr. S. Barwa, Leonard, Government Advocate, representing respondent numbers 3, 4, and 5. Accepts notice. First off, requisite extra copies of the petition be served on them in course of the day. Next para. The learned standing counsel for the Revenue Department places reliance on the case of has referred to the case of Reliance General Insurance Company Limited versus Shashi SHESHI SHESHI Sharma SHARMA decided by Three-Judge Bench of the Supreme Court of India, inter alia holding that the dependents of the deceased cannot maintain dual claim against the state compassionate assistance scheme as well as motor accident claims tribunal. Next will be the receipt made, written affidavit to that effect we file. The consent received respondents. This is very convenient for this. The tendency of this revision shall not be a bar for the concerned respondent authorities to examine the claim of the petitioner and do the needful, if so advised, list after 4 weeks.
Yep, much of that.
Item 14.
After the petitioner has assigned the order.
Just a second. Petition notice, we understand.
Lordships, in
Yeah.
any case, we'll have to verify because the Lordships may kindly note that the father-in-law had also filed a writ petition before this honorable court. And what was
I
the
think few days back also similar matter came.
a few days back, your Lordships
Yeah.
had dismissed that petition saying that a family has to be taken as a cohesive unit.
Yes.
So I'm not sure whether the father-in-law has already been, perhaps it is a possibility that because of the case which he had filed, he might have been paid some amount of compensation. And therefore, the only amount which could have been paid to this petitioner was 2 lakhs rupees, your Lordships. I'll have to
You
just verify
see,
my,
If I, what do you call, just a moment.
Lordships,
This is the same matter.
no, this is not,
26. I think it's the same matter.
Lordship,
Where is the,
no, Lordship,
where is the document of father-in-law?
Lordships will find that at page, Annexure 4, page 53.
53.
That is the order passed by this honorable court.
Yes, this is the same matter.
But
This is the matter we closed.
how come it has been listed again? What's
No, because we closed it, I'll tell you why.
Lordships?
We closed this matter because the same lawyer appeared for the father-in-law. And therefore we closed it.
Okay, so this is a new
This is a new
New set of
new set of counsel for the same.
for the same.
Because once I
Instruction.
once
Oh,
I
gotcha,
once I read the file,
I was also wondering that I've
Something
gone through
says
the
that.
same facts. Anyways,
something
Same thing has
stays
been filed again.
something stays in the mind.
right.
That is the difficulty.
तुम्हाला तो exactly दिया नहीं.
But you will not get any Mr. Mawar, we
तुम्हाला
can't
order
give you
तो
any
लगे वो
relief.
लगे ना यहाँ पे.
You see,
As per details of.
No. You see, once you permit your father-in-law to come to court for a compensation, and thereafter the wife comes.
No, my lord, the father-in-law has not given any penny, my lord.
But that statement is not made in the writ petition. Lordship. Unclear facts is
Once
not.
it is there, you fight out with your father-in-law.
And there is one contempt petition also pending, my lord, before.
That's okay, but whatever is
No, notice may be issued, my lord. And
No. You have to dismiss it. If you have any, you see, whenever this compensation comes arising out of contempt or otherwise, you have to fight it with your father-in-law. You must make a claim, ask for modification of that order. You can't annex that order and then say that my father-in-law also got a claim, and therefore we have not been paid, so I make a claim. That can't be done. Adjudication against a deceased can only be once. To you, if you have got an order, if your father-in-law has got an order of the court, you ask for modification, ask for your impleading and to hear it again in your presence. But we can't permit multiplied litigation.
Lordships, was it not incumbent upon him to have at least made a statement that I had also filed another writ petition which was withdrawn with liberty? Even that has not been made in this writ petition, Your Lordships.
No, but
It
you have
is
to find out.
unclear.
Paragraph
So why?
Paragraph 11, I have.
You should have
Paragraph
11, my dear. I have
11.
to do
716. Yes, Your
that, my
Lordships.
lord. I've stated my lord.
Yes, yes, it's there.
Correct. We close it, we permit you to ask for modification of the order, but we can't permit your petition. It will lead to a anomalous situation where we will not be able to handle the fallout of the order. Supposing we allow your petition, then what happens? Without hearing your father-in-law, we can't say that the appropriation of the receivables will be between the two. So then we are multiplying another petition. So ultimately you'll have to go for modification of the order. Heard. Mr. A. Mubarak, learned counsel for the petitioner. Also heard. Mrs. R.S. Chaudhary, learned standing counsel for the respondent number 3. As well as Mrs. Barwar and government advocate appearing for respondent number 1, 4, and 5. And finance will be for finance. Mrs. R. M. Barwar and standing counsel for the finance department appearing for respondent number 2. That's fine. In the outset, the learned counsel for the petitioner has submitted that the petitioner has approached this court earlier by filing WBC 1787 of 2024, which was permitted to be withdrawn with liberty to file a fresh. Accordingly, this writ petition has been filed again. Where is this order of 7/6/2022? Which page?
He hasn't annexed it, Your Lordships. Oh, 2022, Lordships, yes. That is at page,
22.
page annexure 5, page 65, Your Lordships.
65.
This is also almost 2 years old, Your Lordships. More than 2 years have elapsed, almost.
Next paragraph. By this writ petition filed under Article 226 of the Constitution of India, the petitioner has prayed for questioning of the order dated 7/6/2022, passed by the Secretary, District Legal Services Authority, Dhuri, by which the petitioner was allowed a compensation of was awarded a compensation of rupees 2 lakh as final compensation to the victim under Assam Victim Compensation Scheme, 2012. The next paragraph, the case of the petitioner is that husband, Noor Islam, NUR-IS-LAM, went missing on 4/8/2011, and his dead body was recovered on 1/9/2011 from a jungle. And accordingly, Bilasipara PS case number 549 of 2011 was registered. Full stop. In course of time, charge sheet was submitted in the said case, and the matter was tried as sessions case number 170 of 2014 under section 120 capital B, public 143, public 149, public 302, public 301 IPC. Full stop. In the judgment passed in the said sessions case on 10/10/2018, the learned additional session judge, Bilasi Para, had recommended victim compensation in favor of the petitioner. The said order led to the District Legal Services Authority, Dhubri, taking up the issue of compensation and awarded the compensation of ₹2 lakh by impugn order dated 7/6/2022. Next paragraph. In the meanwhile, the where is the current new notification of 2019? Where is that?
Enacted to my lord.
Page
Page 23.
the Government of Assam had issued a notification dated 1/2/2019
Serial number 6.
by which the quantum of compensation has been increased to
Serial number
rupees
6. 5 lakhs.
5 lakh.
Serial number 6, my lord.
Okay, fine. Under serial number 6 of the schedule thereof. Accordingly, it is submitted that the petitioner would be entitled to a higher compensation. Next paragraph. The learned standing counsel for the respondent number 3 has drawn the notice of the court on the judgment and order dated 3/4/2019 as by this court in WPC 1547 of 2019. Which was filed by one Abdul Abdul Manan MANNAN. Stop. He said Abdul Manan is stated to be the father-in-law of the petitioner. Stop. So it is something that the said Abdul Manan, or the petitioner in WPC 1547 of 2019, had approached this court for taking the benefit of Assam Victim Compensation Scheme, 2012, in connection with Sessions Case number 170 of 2014, and this court by order dated 3/4/2019 allowed the writ petition by directing the District Legal Services Authority, Dhubri, to take up the claim of the said Abdul Mannan, petitioner in WPC 1547 of 2019 for victim compensation under Section 357 capital K CRPC after due inquiry. And decide the quantum of compensation to be awarded in terms of the government notification dated 1/2/2019 within 2 months. Next, it is submitted that for non-compliance of the said order, as per her instructions, contempt petition is also pending. Next paragraph. Under such circumstances, the court is of the considered opinion that if already there has been an adjudication with regard to entitlement of victim compensation under the Assam Victim Compensation Scheme, 2012, which was in favor of Abdul Mannan, the petitioner in WBC 1547 of 2019, it will be open to the petitioner choice of taking recourse of two take recourse to either of the two remedies available to her. First off, it would be open to the petitioner to have a judicial order of sharing of the compensation between her and the father-in-law, and of the God to demonstrate her fair right to have compensation in precedence to the right of the father-in-law to receive compensation. So the second option open to the petitioner is to apply for modification of the judgment in order dated 3/4/2019, passed in WBC 1547 of 2019. So that conflict of judicial opinion can be avoided. Full stop. Next paragraph. Be that as it may, subject to whatever choice the petitioner would like to avail. In this case, the respondent number 3 has demonstrated that an order has already been passed for granting or award of victim compensation to Abdul Mannan. Petitioner in WBC 1547 of 2019. Stop. Therefore, the order dated 7/6/2022 impugned herein appears to be in direct conflict with the directions contained in order dated 3/4/2019, passed in WBC 1547 of 2019. Stop. Therefore, the subsequent order dated 7/6/2022, passed by the Secretary, District Legal Services Authority, Dhubri, cannot be implemented till the order dated 3/4/2019, passed in WBC 1547 of 2019, remains in full force. What is that?
She's already received that 2 lakhs rupees. To my instructions are that she's
Okay.
already received
So
that.
what is that Latin term? Proprio vigore.
Lotships.
Tokyo Vigore.
Lotships.
What? Next paragraph. The next paragraph. At this stage, the runner standing counsel for respondent number 3 has submitted that he has just received instructions to the effect that the victim compensation under the Assam Victim Compensation Scheme has already been released to Abdul Bandan, the petitioner in WPC 1547 of 2009.
No,
madam.
no,
Pretty sure.
to the petitioner, to the
This
petitioner,
petitioner.
this petitioner, 2 lakhs.
Always 2 lakh to the petitioner. Pursuant to order dated 7/6/2022, passed by the Secretary Legal Services, District Legal Services Authority. You have a date also?
No, I don't know.
That's right. Once the,
Moving on.
next one. Once the said order has been complied with and the compensation has been received without any protest. Even otherwise, this requisition has become infructuous. Full stop. Next, be that as it may, in view of the observations made in this order, this requisition stands closed. Next, the learned government advocate shall transmit a copy, the downloaded copy of this order to the District Legal Services Authority from Adhaar for their information. You transmit it there, then she will transmit it there.
Replay back.
Fifteen.
Wait, please, Lordship. Matter relates to the challenge of notification whereby time limit was extended, my lord. Lordship has passed similar order, my lord. I have given the copy, my lord.
You have done the corrections?
I will do it, my lord. I will do it. Lordship allows. Item number 15, 16, and 18 are same, my lord.
Just give the corrections.
15, 16, 18.
Mr. R.S. Gupta, counsel for the petitioner. Mr. S.C. Kyal, standing counsel for the GST, appearing for respondent number. Your name? Ms. M. Dekar, learned counsel, appearing on behalf of Mr. S.C. Kyal, standing counsel for CGST, representing responding numbers 1, 2, and 1, 2, 3.
I am for central government.
Okay. Just say, number 1 is K. Fukan, learned. She's appearing for respondent number 1. And she's for 2 and 3. And Mr. V. Chaudhary, standing counsel for the state GST, appearing for respondent numbers 4 and 5. Same order. Just check it up.
Yes. Well, only one thing is in item number 18, my lords. They have issued 2 so-called notice on same set of facts, same figure, my lord. So since the lordship has passed order allowing them to proceed with the so-called notice, so they may proceed with only one so-called notice, my lord. There are 2 so-called notice, my lord, on different dates. Item 18, my lord.
18.
18, my lord.
The item 18, I'll show to you, right? Just write the line. The learned counsel for the petitioner submits that in respect of identical demand from our 2 show cause notices dated.
One is 24/7/2023 and another is, my lord, 06/12/2023.
Were issued. Just call. Before. the who is the judicial authority?
My lord, item number 5, my lord.
The respondent of 5 shall intimate to the petitioner in writing as to which of the two show cause notices shall be proceeded with. Mr. After due notice to the petitioner, the respondent of 5 will proceed in the matter, fixing a date for the date for filing of show cause reply by the petitioner.
Deeply obliged.
25 copies before respondent of 5.
5, my lord.
Item 17.
Wait, please, your lordship. Lordship, in this case, the petitioner is challenging the impugned WhatsApp message dated 22/2024.
You can only issue a notice right now. Will issue a notice.
Lordship, in this case, my lord, after filing of the writ petition, the respondent number 7 again served a notice, my lord. They are going to close the gate, my lord.
But that is there, you see, if it's an unmanned gate. If to avoid accident, if they are closing it for the timing, you'll have to accept
But
it.
my lord, it is against the resolution adopted by the deputy commissioner, my lord. It is there in the minutes of the meeting held on the 6th June 2015. my lord.
Deputy Commissioner can't give a direction to the.
But my
railway
lord,
authorities.
the respondent also acknowledged the same, and they are going to man this railway crossing with another crossings, my lord. And they have issued one letter to the deputy commissioner.
No, you see, we can't take the responsibility. The court can't take a responsibility for any accident. You have to have a diversion for a few days.
It's all about compliance of the order, my lord. Lordship may kindly come to
You see,
please.
District Transport Authority or the Deputy Commissioner does not have jurisdiction for the matters of railway. They may take a decision as a secretary RTA for other traffic, not for railways. Railways, they will be out of bounds for the Deputy Commissioner. They may have made an agreement. But we don't know about the enforceability. For the central government, the Deputy Commissioner would not have the jurisdiction and power.
Lordship, but the railway authorities has decided to merge few unmanned level crossings with the manned
It's
level
okay,
crossings.
we'll give him a
And-
notice. You will respond to it. We'll also issue a notice on the prayer for interim relief, and that will be considered on the next date. Where is that Deputy Commissioner's agreement?
It is at page, my lord, 78.
78.
78 is the type copy, my lord, and the original copy is at page 81.
But Mrs. M. Sharma, running counsel for the petitioner, and Mr. H. Gupta, running CEC, appearing for the respondents. Respondent numbers
1 to 7.
1 to 7. And as per one government advocate appearing for respondent number 8. 8 to 11. Oh, for PWD, you are there. 8 to 10, and Mr. P. Nayak, and Mr. Counsel for the PWD with respondent number 11. The communication to the petitioner for closing down, for permanent closing down of unmanned level crossing number 76/6-7. which which would impede transportation of goods from industrial complex. Sorry, GB Gatani, G full stop B full stop Gatani, GATTANI, industrial complex. And Bagdara, BAGHDARA, Basti to Jorhat Mariani Road is assailed in this requisition filed under Article 226 of the Constitution of India, alleging that the decision is contrary to the minutes of meeting held on 6/6/2015 from the Office of the Deputy Commissioner regarding railway crossings in Jorhat Moriani sector. Explanation notice, including notice on the prayer for interim relief returnable on. We give you 3 weeks time.
Well,
Give a date after 3 weeks.
My lord, till date, no coercive action.
No.
Because my lord, tomorrow they will going to.
Even if they do it today, we are not stopping it. Who takes the responsibility?
Because lordship, there is a guidelines also issued by the railway board.
You see, we have
The existing
known that.
level crossings, they cannot, why not close down.
We'll see to that, but today we are not giving an interim order. The reason is very simple. There's the Deputy Commissioner's meeting which has persuaded us not to give the order. But the Deputy Commissioner has no right under the Railways Act to pass any order in respect to the area within the railway jurisdiction. But they are all, this is something which could not have been done in the first place. The power of the Deputy Commissioner is limited as a state secretary motor, what you call state motor, STA, what is STA? State Transport Authority. His role is very limited. Give a date after 3 weeks. 20/5/2024. Stop. The respondents in the railway department shall ensure that their affidavit is filed within that time. Next prayer. List on 20/5/2024. On which date an attempt to be made to take up the prayer for interim relief.
EP open.
Nineteen.
I mean, this is the letter lordship at page 39,
Just a moment.
by which a proposal has been sent to the government for cancellation of my particular lordship, which was earlier allocated lordship.
Okay. I'm showing notice.
Lordship,
Yes.
ultimately, Lordship, a series of matters are fixed on tomorrow.
Tomorrow. We
Yes.
should notice in the meantime.
Lordship, if your lordship comes to page 33,
Okay, we are issuing a notice.
Otherwise, a similar matter has come on day after yesterday. It is fixed on day after tomorrow. Similar.
No, in this case, can you get instructions by tomorrow? If you say yes, then we'll fix it tomorrow.
Then Lordship issue notice.
Because you see this, you'll have to get a specific instruction with regard to the petitioner.
yes,
He has his own claim, which is independent of others. Is it not?
No, he is also a part of that series.
No, I understand. He is a part of series.
Yes, Lordship. That's what. In
I
between,
am part of series, lordship. But
Then you can't file 2 petitions. Your petition has to be dismissed.
no, fact is, this is the
some subsequent.
subsequent development lordship. This is at page 39. Proposed
Page
for
39.
cancellation of my
Page 39.
particular.
Then his requisition is maintainable. You have to issue a notice.
Lordship.
If you can get an instruction for him by tomorrow, well and good. But I don't think your authorities are that prompt.
let it be fixed on tomorrow, then lordship, without issuing notice.
We have to
Otherwise- or day after tomorrow. What will be the what?
Mr. Adhaar, counsel for the petitioner is present. On the prayer of Mr.
SR Borwa.
S.R. Barwa, and
Government advocate.
Government advocate. And
Correct.
Ms. P.R. Monthor, and it's standing counsel for the revenue department. In my is John Cray, list in the motion column on.
Friday, lordship.
Friday, 10, I'm sorry,
26.
26.
Friday is 26. Okay.
In the meantime, if they can obtain the instruction, lordship.
He's asking for day after tomorrow, we'll definitely do something.
God bless.
Item 20.
May I please, your lordship?
Yes,
Your lordship, before I take your lordship to the very issue involved in this petition, your lordship.
just a moment. Now, what is your interest in this petition?
Your lordship, I'm a resident of the Sonitpur district, your lordship. And because of that, your lordship, I reside nearby. And I've also filed an RTI, wherein, your lordship, there's a human-animal conflict, which has resulted in the death, your lordship, of many civilians, your lordship. Your lordship, my interest has a sufficient interest, your lordship, because a public duty has been bestowed upon the state respondents, your lordship, and there's a breach of that duty. And Sonai Rupai Wildlife Sanctuary is in the Sonitpur district, your lordship.
Who's appealing for forest, you are appealing? You should notice them.
Lordship, this is mostly in the nature of PI, lordship, and if lordship looks at the
But he's
PI
paid a court fee. Is there any bar for somebody to move a writ petition instead of a PIL? He does not want to go it as a PIL.
Yes,
He's
your
moving it himself. He's
but lordship, perhaps the petitioner will have to demonstrate that a legal right has been violated.
he has told us, he has said that he resides there. And therefore, he says that the based of political parties, enforcers are being shifted into the forest area. His prayer before the court is to make an inquiry as to whether these people, enforcers who are there in the forest area,
Yes, sir.
are forest dwellers
Yes.
under 2O, I think.
Yes, your lordship.
That's what he's saying.
And
Can the forest department come and say that he doesn't have a locus standi?
Yes, your lordship.
Lordship will take notice.
Your lordship, I'm just troubling your lordship. Your lordship, after filing of this writ petition, your lordship, there was a PIL which was being filed by a different set of party, your lordship. May I just produce a copy of it? Your lordship?
This PL is disposed of.
Yes, your lordship. Your lordship, there is an admitted position by the respondent number 7 that
Inquiry is going on.
there has been an encroachment. And the principal secretary also wrote to the honorable CM on
You've seen that,
27.
you issue a notice.
Yes, your lordship.
You've seen that. Heard Mr. D.S. Dekatan, counsel for the petitioner. As well as Mr.
I bought it.
I. Bothako done it. Standing counsel for the forest department. You're appearing for all the respondents.
For 9 and 10 SSA.
Respondent numbers 9 and 10.
For SSA.
So
I
you are-
got 8.
CGC is appearing, who's appearing, you are appearing. The first, right, her name, says Babar and CGC appearing for respondent number 1. Forest, you are there,
I'll appear for 2 to 7.
2 to 7. Then as government advocate will be appearing, Mr. Barwa, Mr. S. Barwa and government advocate appearing for respondent number 8. No, 9 and 10, Mr. Nayak.
Yes. I have 9 and 10. I have
9 and 10, 11.
I am the SSA 5 here. 9 and 10.
Just a moment, Mr. P. Nayak, because standing also for respondent number 9 and 10.
11 and 12.
For
9 and 10.
you are
4 hours. I am right.
That's
For
11 and 12.
okay, 9 and 10, Mr. S. Bora. 11 and 12, Mr. P. Nayak, standing also for PWD. The petitioner who resides near the Sunai Rupai Wildlife Sanctuary has projected that the said wildlife sanctuary is infested with encroachers and in the process the provisions of forest within bracket conservation bracket was act 1980 the wildlife within bracket protection bracket was act 1972 have been violated. It is also projected that the concerned authorities are not only permitting enforcement within the forest area, but they are also issuing permission for constructions, including construction of illegal roads, which has led to depletion of the forest area. First of all, accordingly, it is submitted that the respondent authorities are required to make an inquiry as to whether the encroachers are persons from scheduled tribes and other traditional forest dwellers and if not, the protection under the scheduled tribes and other traditional forest dwellers within bracket recognition of forest rights bracket closed Act, 2006 should not be extended to them. According to the petitioner's read, for directing the respondent authorities to ascertain the total area encroached within the Sonai Rupai Wildlife Sanctuary and to initiate process of determining the rights of traditional forest dwellers and to take appropriate action. Next para. The learned standing also for the Forest Department has raised the issue of maintainability of the lead petition on the ground of lack of locus standi of the petitioner to maintain this lead petition. In that regard, the court is of the considered opinion that as a citizen, if the petitioner has come forward with an intention to protect the Sonai Rupai Wildlife Sanctuary, he would have a the locus standi to maintain this lead petition. Because although the petitioner is not seeking any relief for himself, but the nature of relief sought for would benefit the the state of Assam by protection of the wildlife sanctuary. So accordingly, the writ petition is found to be maintainable. Next, issue notice including issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the state and departmental council in course of the day. List after 4 weeks. Take a break and come back. Item 21.
Please loss.
Issue notice here.
Loss. While the notification has been rescinded by another notification.
Bring it on record. Since he's filed it for his proposal, bring it on record.
Yes.
Mr. M.H. Ahmed, Council for Liquidation. If a decided on its conditions for the revenue department, then if there is a other state respondents. So we think that the husband of the petitioner, number one, died due to COVID-19 pandemic while performing duty on 1/10/2020. The petitioner is filing his petition on Article 226 of the Constitution of India, seeking ex-gratia payment. The learned standing counsel for the Revenue Department has submitted that as per his instructions, the ex-gratia by form dated 8/10/2020 has since been rescinded. Be that as it is, the notice returnable in 4 weeks, we will get extra copies of the resolution we serve on the government. State and department council in course of the day. Pendency of the resolution shall not be barred. Respondent of public to examine the claim of discussion. Pass a paper for this. List after 4 weeks. For RTI information, which has not been received, and accordingly this petition has been filed. And Article 226 of the Constitution of India. Mr. S. Barwal and the Government Advocate accepts notice on behalf of all the respondents. All the respondents.
The fourth is the secretary of the Samavai Committee.
So he's a government employee.
Secretary.
Secretary becomes a government employee. Maybe Corporation Department can receive it, I think.
Pardon?
Corporation Department.
Operation.
Yes, G. Borderline.
Yes.
He would be proper to receive his. So Samavai is Corporation Department.
Yes, Samavai. Borderline.
G. Borderline. Okay. Correspondence 103 and it's a G. Borderline and it standing also for the Corporation Department appearing for respondent number 4. Accept notice. Requisite extra copies of the petition be served on them in course of the day. Next part, the pendency of this petition shall not be a bar for the concerned authority to provide the requisite information to the petitioner. List after 4 weeks.
No, I will furnish the copy by tomorrow, man.
By tomorrow, within 2 days. Okay.
Oblige, my lord.
Item 23.
You have to oppose the magistrate under one.
Yes, magistrate logically order annex 10, page 89.
Page
89.
89.
And the page 90 is the order. OC is the main accused in that case. Football is directed the OC, that OC to inquire the matter. Then I file a complaint also, DGP. Page 91. After getting that information, that was got Khaudias.
Yes, then we are issuing notice.
Yes, I should.
Heard Mr. J. Ahmed and asked for the petitioner.
Or else, Lordship, I can also have an instruction as regards this order, what action has been taken, whether it has been raised.
He says that the OC himself is an accused, he will not take
Yes,
action.
he won't.
So. In this repetition, it is alleged that despite order dated 12/2/2024 passed by this court in CRP 182 of 2023. The officer in charge of Buragaon Police Station came to the suit land with some persons named in the petition and dismantled the house of the petitioner. Full stop. The petitioner gave a complaint to the Director General of Police on 1/3/2024. And as no steps was taken, the petitioner.
Now, before that, I filed a complaint to the
Oh, sir.
CGM.
Oh, okay. No, not that. The sequence will be changed. Thereafter, the petitioner had filed a complaint case before the competent court, which was made over to the Additional Chief Judicial Magistrate Morigaon, and the said learned court by order dated 26/2/2024 directed the officer in charge of Buragaon Police Station to register a case and to conduct an inquiry. Thereafter, a complaint was made by the magistrate, by the petitioner before the Director General of Police assigned on 1/3/2024.
15/3, next one. Right?
Huh?
One, thereafter, I again file on 15.
Where
91, page 91.
91.
I mentioned there about.
Was followed by another letter to the Director General of Police Assam on 15/3/2024. The learned counsel for the petitioner submits that as the officer in charge of Buragaon Police Station himself is an accused, neither any case has been registered nor any investigation has been taken up. Hence this petition under Article 226 of the Constitution of India. Next paragraph. Issue notice returnable in. Give a date after 5 weeks on so and so. Issue notice returnable so and so. Mr. S. Barwal and a committee advocate accepts notice on behalf of respondent numbers
1 to 7.
1 to
7.
7. Requisite extra copies of the requisition be served on him within 2 days. That's why the petitioner shall take steps within 2 days for service of notice on respondent numbers 8 to 21 by registered post to the Next, the learned counsel for the petitioner is at liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. The pendency of this writ petition shall not be a bar for the Superintendent of Police, Morigaon, within bracket respondent number 6, to have the matter inquired Next list on
12th of June.
12
June.
June.
Right, June. 12 June.
Municipal, you can transmit the order of the court to SP.
DGP, my lord, DGP is the
DGP,
No,
DGP.
to the SP.
SP, Morigaon.
I will transfer.
The government advocate, let's send a counter copy of this order to the superintendent of police, Morigaon, who can take a respond number. His respond number 7.
6. Six, my lord.
6. Dispensation. Okay.
Supplementary item 54.
I will get some protection.
No, after demolition of house, what protection you need? You want that for your
Because
foreign items?
I clearly mentioned that he will threaten me to register a case against me.
No, that doesn't happen. It's
Well.
there. Yes, item 54.
Yeah, application for arbitration of. Without earlier occasion, I was directed to bring on record the contract agreement. There is no separate contract agreement except the annexure 1. But I have brought on record one document which shows that applicability of IAW 2249 million. Because
No, something is wrong here. You have not filed the entire document
relating to Milord.
relating to your contract.
Yes, Milord. But Milord, this was the
You see, come to page 18.
Yes, 80.
Come to page 18.
Yes,
18
ma'am.
says that there are total 72 pages.
Yes, Milord.
Where are those 72 pages here?
No, I have not, actually relevant portions I have.
Oh, don't think that.
Entire.
You see, you have some experience in this court. You have some experience appearing in this court before this bench. You have an experience. Have you seen that I read only the relevant part and don't touch the irrelevant part? Have you seen that?
Then
That I have incompletely read the,
I shall be.
I have not read the brief and come. Don't make a choice.
Well, the last occasion, there is submission made on behalf of petitioner. In terms of the earlier order passed by this honorable court on 23, 2024, he is required to submit the entire contract agreement. And there is a submission day before yesterday that additional affidavit has been filed. Of course, I don't have the copy of the same. To bring on records the CA, I don't know whether that additional affidavit has been filed or not.
No, no, last occasion I was.
No, incomplete document are not.
I additional, another.
As the both sides are represented, as the documents are incomplete, the court refuses to take up the matter. Matters can be adjourned today, list after 4 weeks.
No, after 2 weeks,
No. When you don't file copies, you take risk. Mr. Sahu,
Look,
you do one thing. Come tomorrow morning at 7 o'clock in the evening. I'll give you all the briefs which come to me. You collect those briefs, 50, 60 files which are coming to me. Read that in the morning and be prepared with the notes tomorrow morning at 10:15. Give me your notes of all the matters which I have on board. Do it tomorrow 10:15. We recall this order and we give you 7 days time. Read the brief and tell us. You think it is fun? You can't read one brief you are having in the court. You don't even know what the document is missing. I have to tell you that there are 72 documents in the contract agreement. You don't even know your brief. And you are telling us what to do. Reading is not easy. You look upon yourself. You will find out. Being here in court till 7:30 in the evening, going back to the home and reading the brief and coming here prepared. You think it is fun? Don't do it. Don't provoke the court. Even in the last matter when I am taking up, I think I do my best to go through the brief. You do one day tomorrow. Today evening at 7:30, collect the brief from us. Go home, study and bring me the notes. And I'll do whatever you say. You dictate, you write your order and come, we'll sign it. I give you that much of liberty. Do it tomorrow. Today 7:30, come to courtroom, take the brief from me. Read that tomorrow's brief and come. If you don't know how to read your own brief, which you are having, I'm sorry to say that please don't tell us what to do. Read your own brief and come. Don't provoke the court. I love to live a happy life, smile and go back home. My idea is to die peacefully. But if you provoke me, I can be harsh. It's not that I don't know how to shout. I don't do it because it is not my character.
Sorry, Lord.
I love to live like a happy man and die happy, if God willing. That's why I smile every time. Even at the worst of the occasion, I try to smile. Don't provoke us. If you can't read your own brief, please don't tell us what to do. Yes, Mr. Agarwal.
24 items.
Yeah. Oh, 24. What is 24?
Item 24.
Just a moment, let me cool down. Let me have a glass of water and then I'll be back to my square one. I'm sorry, I lost my cool. Just a moment. Yes.
My file objection or objection in time.
You still allow it. This has to be included.
Actually, my lord, applicant is neither a necessary party nor a proper party for in this matter, my
So
lord.
that's okay. In this application, she says
My lord.
that you have initiated an eviction process
My lord.
where she is affected.
No, my lord.
Is she right or wrong?
My lord, no, my lord. She is not affected. my
She is
lord.
not right. Then we pass an order that in your writ petition, she will not be evicted without due process of law. End of the matter, we reject her application.
May I, my lord? Pardon, my
Yes.
lordship. But as per them, according to their.
No, you forget what she's saying. I'm asking you a question.
My lordship.
My question to you is, in this interlocutory application, she says that in your writ petition, you are seeking an eviction which affects her.
No, my lord. I am seeking an adjournment of the affection by eviction, my lord.
So whatever, but if it affects,
But she will never be affected, my lord. It is only, my lord, if the eviction process is continue, my lord, I will be affected, my lord. According to them, my lord, the applicant, my
up to
lord.
this application, yes.
May I submit, my lord?
Just a moment, let her say. Oh, your process is been evicted, huh? Yes.
my lord.
So she's the necessary party. If it is at her, I'm sorry, I misread. She said that at her initiation, you are sought to be evicted.
As per their application, my lord.
We have filed
Why,
complaint.
why she will not be heard?
Yes, ma'am. But my lord, our prayer, limited prayer, my lord. Only prayer is that initially it was a patta land. The petitioner's father is a pattada of this land, plot of land. After expiry of the petitioner's father, my lord, in the year of 2001, my lord, said plot of land was mutated in favor of the petitioner along with his other siblings, my lord. Subsequently, in the back of the petitioner entirely unknown about the fact that in 2003, my lord, a case, RK case number 4/2003 was initiated, and the said plot of land converted to government land, and subsequently a new new dark number is created as 6 to 7, my lord. Our prayer is that, my lord, and during that process, when we come to know there is a eviction process is to be going on, my lord, when the circle officer informed to coming this place, my lord, then we inquire all the matter and come to know that there it was on the back of 2003, my lord.
You come to page 68, Annexure B of this interlocutory application. Why it is numbered at 68? Why? 68.
My lord, running page, my lord.
Yes, ma'am.
Okay, this is 68.
My lord.
This is the complaint
Yes,
for
ma'am.
eviction of government land.
Yes, ma'am.
You are in this land?
Yes, ma'am.
Correct. Now come to page 69. Her name is, the name of the petitioner is, the applicant is number 1.
Yes, my lord.
Then?
Yes, my lord. But my lord, our prayer, only limited prayer is that to provide the copy of these documents, my lord, of the RK number, case number 4/2003, my lord. That is our prayer, my lord.
No, but it has to be in her presence. Once she is the complainant, it has to be allowed. Whatever your simple prayer be. But if she has initiated that. But this is SB Chaudhary and counsel for the applicant. As well as Mr. K.M. Hassan, learned counsel for the opposite party number 1. No, sorry, you will be opposite party number 1. So the opposite party number 1 is the read petition is in the connected read petition. Next para. By filing this interlocutory application, the applicant seeks impediment as respondent number 8 in the connected read petition by projecting that on a complaint initiated by him and others, the eviction process of the petitioner has been initiated. Next para. The learned counsel for the opposite party number 1, by referring to the affidavit in opposition filed in this matter, has raised a preliminary objection as to maintainability of this application. The learned counsel for the petition for the opposite party number 1 has submitted that the land was originally a private patta land, which has been converted behind his back to a government land. And therefore, the limited prayer in the writ petition is to provide him with a copy of the concerned. What is the full form of RK? I forgot. Revenue. RK case. What is the full form? on the concerned RK case on which the process against the petitioner was initiated. Accordingly, the learned counsel for the opposite party, number one, submits that the petitioner is neither a proper nor a necessary party in this, in his writ petition. Next paragraph. From the documents annexed to this interlocutory application, comma, the applicant has, it is seen that the applicant has annexed a copy of the complaint dated 23/5/2023 before the Deputy Commissioner, Nagaon, for evicting encroachment from the government land. Full stop. Therefore, is the process of the process of eviction of the petitioner has been initiated at the behest of the petitioner or the applicant. The cause of the constitutional opinion that the applicant is a proper and necessary party, as the applicant does have material interest in the subject matter of the connected writ petition. Accordingly, this interlocutory application stands allowed. Then pass an order in writ petition. Mr. K.M. Hasan, counsel for the applicant, sorry, writ petitioner, and Mr. S. Barbar and Mrs. S. Barbar and government advocate appearing for respondent numbers 2, 3, 4. This Zilla Parishad will be appearing. PMRT. So before that you write for government will be appearing. Oh, one. Okay, this is PR Monster and government advocate appearing for respondent number 1, and Miss N. Bora Leonard, counsel for respondent number 5 and 6. Also heard Mrs. S. B. Chaudhary Leonard, counsel for Kitab 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 Ali. Sorry, not Kitab Ali. It is Habibur Rahman. HABIBUR Rahman, RAHMAN. Whose impleading application as respondent number 7 is allowed by order passed today in IA Civil 244 of 2024. Next paragraph, the petitioner shall provide a type copy of the new cost title of the parties and submit the same before the AOJ civil pending section. And on receipt of the same, the registry shall make correction in the central registry and of the applicant in IA Civil 244 of 2024 implemented as respondent number 7. Next paragraph. Notice is also issued on respondent number 7. Returnable. We give you 2 weeks time. Returnable. Give a date after 2 weeks.
Till then, my
okay, we extended. No ground so and so. You have a copy of the petition, later copy of the petition will be provided to her in course of the day. Next for the
Tomorrow, my lord.
interim. Okay, within 2 days. Next for the interim order passed on 21/12/2023 stands extended till the next date of the same.
My lord, there is another interlocutory application, my lord.
Where is that?
That is there, my lord, IA number 253.
253.
This is for vacating the interim order.
Okay, 5253. Mrs. S.B. Chaudhary, counsel for the applicant. Mr. T.M. Hassan, counsel for the opposite party number 1. Mrs. P.R. Monthod, standing also for respondent number 2. Mrs. Ms. Barwar and committed to get appearing for respondent number opposite party number 3, 4, 5. And Miss, I forgot your name again. And Bara, counsel for opposite party number 6 and 7. No, here it will be 6 and 7. Issue notice on this interrogatory application, returnable in 2 weeks. Requisite copies of the, you have got copies?
My
No, okay. You list after 2 weeks.
17th of May.
17 May. Give a date.
Obliged.
25 with 26.
My lord,
Yes.
by this liquidation, my lord, petitioner has challenged the, my lord, impugn draft
Lordship, the
notification,
matter
my
has
lord.
become infructuous because that
But I have to
impugn
say
order
something.
has been withdrawn.
My lord, withdrawn. Here problem is this, my lord, I cannot appear on behalf of the petitioner in view of the, my lord, section 35K. Because the company is in liquidation now. Company is in liquidation now, and 35K says that, my lord, to issue it, or defend the suit by the only liquidator. So whatever my learned friend is saying, my lord, you can record, but I cannot submit, in fact, to be recorded.
But we'll record your submission. Don't worry.
That, my lord, that part that I am not entitled to defend.
Okay, okay. Mr. R.K. Agarwal and counsel for the petitioner is present and submits that in view of
Section 35K. 35K of the IBC. K.
Of the IBC code.
Yes, as well as, my lord, the liquidation order.
He is unable to.
The order for liquidation.
No, he cannot appear for the petitioner.
Petitioner. And as well as in view of, my lord, the liquidation order passed on 18/12/2023 by the NCLT Guwahati.
No, second. What it was 35 K.
K. Small K.
Small K. Of the IBC.
IBC
code.
2016.
2016.
16.
As well as in light of
in view of order by the Honorable NCLT Guwahati bench.
Order dated 18/12/2023 passed by the NCLT, Guwahati bench in IA within bracket IBC bracket closed /3 /GB /2023
in CP
in CP within bracket IB /GB
IB 18 euros.
What did I say?
IB then
18,
stock and 18.
IB /18 GB 2021. Is unable to appear in the
and
matter.
defend the case.
Stop. His submissions is recorded. Next para. Mr. B. Chakravarti Leonard, CGC, appearing for the
Respondent number 1 only.
appearing for the respondent number 1. has submitted that he is in receipt of instructions dated 12/1/2021 by the Undersecretary to the Government of India, Ministry of Health and Family Welfare, Government of India, Department of Health and Family Welfare, Food Regulations Section, that the order impugned in this repetition has been withdrawn.
On the basis of that, several writ petition, that copy has been in the file before the Delhi High Court has been done. About
Several high court, madam, several.
all high courts.
Several high courts.
In view of orders passed by the High Court of Delhi in WPC 8834 of 2020 and other connected matters. Full stop. You give a photocopy.
Lordship.
The learned CGC will provide a photocopy thereof to be retained in record. In view of the submissions made by the learned CGC, this matter has been rendered infructuous. According to this matter stands closed.
Stay orders.
You give a copy. Retained.
Oblige yours. After a long time, that too for infructuous order.
It is, but it is not good. Malad, since you can't appear, it is not good.
That's why, Malad, I have got the copy even for the infruction matter. That's why I'm sitting with it. Oblige yours.
It is separate orders. It is separate orders.
Item 29.
Yes. Yes, what does the revenue have to say?
$29.
My lord, as per order dated 19/5, my lord, 23, government take instruction regarding payment of compensation, my lord. It records, my lord. Deputy Commissioner, my lord.
No, but something is horribly wrong. You see, the railways have taken a stand that this land is a government land. By filing an affidavit, they say that it's a government land. And therefore, the railways are asking question as to how in Jamamandi the name of the petitioner could be included. You check this, you have a copy of your affidavit as respondent number 2.
Yes.
You have a copy of that affidavit?
Yes.
Give it to her. You have to ask the Deputy Commissioner to make an inquiry how the government land becomes a private patta land and how the Deputy Commissioner is now assessing government land to be a private land. Read paragraph 4.
The petition department stated the petitioner mentioned that tag number 1046 and pattern number so but in the Jirat book prepared during assessment of Jirat by the Circle Official Revenue Department and Railway jointly that the tag number 1046 is government land, which was occupied by Sri Haridas Kolita, son of so and the land were acquired in the year 1988. Then how the claimant produced the Mamondi copy of dated demand? Also, who were occupied in the land, namely Janaram Kolita.
So government land of 88
yes, ma'am.
is made a patta land in 2000 9.
9.
Now, who will make that inquiry? Obviously, the Deputy Commissioner's office,
Deputy
if this has
Commissioner.
happened, the Deputy Commissioner can't do it.
My
He'll be
lord.
an interested person. So whom should we appoint as a person to make an inquiry?
You have to clarify, my lord, from the Deputy Commissioner office, my lord.
You get it? Because otherwise we'll have to cause an inquiry. We'll have to direct the Revenue Department to have an inquiry made by a person not less than the uh, not less than secretary level.
Yes. Also fix a date, my lord, in the meantime.
Then if you don't call for the petitioner. The
Tomorrow, if we get from 8 to tomorrow, no?
Mrs. P.R. Mounted on a standing counsel for the Revenue Department has submitted that. What is your instruction? That she is in receipt of instructions.
That is. I have not received any instruction.
So what are you saying that?
No, as per orders dated 19/5, my lord, 19/5, government advocate to take instruction, my lord.
No.
The Deputy Commissioner office, man.
The instruction is anything, but we have communicated, but due to election officers.
No, in such matters, the government will have to take, he'll have to take a leave and then do this work. He'll have to apply before the election commission to recuse himself. You see, government land can't be converted into a private pata land like just like that. After it has been acquired in 2000, after it has been acquired in 88. Correct. That is why a few moments back I lost my temper.
My lord, I'll try, my lord. I lost.
No, it's not that bad, I'm telling you. That is why 2 minutes back I lost my cool.
I have to take instruction from the Deputy
No,
Commissioner
that's
office,
okay.
my lord.
That's okay. I'm not telling you. I'm just justifying why I lost my cool.
Yes.
Just say, also, none appears on call for the petitioner. However, Ms. P.R. Montal and standing calls for the Revenue Department. Mr. H. Gupta Raned. CEC appearing for respondent numbers 1 and 2. 1 and 2, and Ms. S. Barwar and Government Advocate for respondent numbers 4, 5, 6 are present. Next paragraph. On a perusal of the affidavit of opposition filed by respondent number 2, it appears that the relevant land covered by DAG number 1046 was a government land that was acquired in the year 1988. Full stop. Therefore, the respondent number 2 has questioned as to how the said government land covered by DAG number 1046 could have been made a pata land in favor of the petitioners as revealed from the copy of Jamabandi issued on 27/7/2009. Full stop. As per if the allegations made therein is correct, would lead to serious consequences. Next paragraph. In view of the said disclosure made in the affidavit in opposition by respondent number 2, the learned standing counsel for the Revenue Department as well as the learned Government Advocate, case for is granted. time till 15/5/2024 to have specific instructions on the stand taken by the respondent but true. Mr. Gupta, please give a copy of your affidavit to them.
It is there.
Huh? Okay, the learned CGC shall provide that extra copy of the said affidavit in opposition of respondent two to the learned government advocate as well as standing counsel for the revenue department within 2 days. Next for a list on 15/5/2024.
Well.
Item 30.
Item 30.
Yes, Mr. Deka.
Oh, yeah, please,
Adhaar card.
in this case matter, I am supposed to bring the up-to-date status. My lord, I tried to contact, but I could not contact anybody. My lord, may kindly give us 10 days time. Within this time, my lord, I will positively bring the up-to-date status.
Okay.
But so far as my information goes, my lord, the similar matter is already pending before the Honorable Supreme Court for disposal. And that may be one of the grounds.
No, Mr. Deka, it may be pending.
Yes, my lord.
But the question is that the petitioner must know what is happening. He has come to court. You file an affidavit, say that it is pending.
Deeply obliged, my lord.
Correct. Because otherwise, people who are in court, they lose faith in the entire system.
Yes, my lord. That I
If
understand.
you have that information, give it.
Yes.
Then we can stay the matter to the disposal of the
Yes, my lord.
issue before the Supreme Court is decided.
Kindly grant me some more time.
Okay. 2 weeks?
2 weeks, my lord.
Huh?
2 weeks will be convenient. 2 weeks will be more than sufficient, my lord.
Okay. Since you'll be filing an affidavit, make it 3 weeks. You can do it by then. I'm not a person call for the petitioner. Mr. B. Deka at CEC has submitted that as per his instructions, the issue raised in this writ petition is also pending for adjudication before the Supreme Court of India. And accordingly, he pays for and is granted 3 weeks time to bring his stand on record by filing an affidavit. Stop. List on up to 3 weeks, give a date. Just before that, you write, the pendency of this writ petition shall not be a bar for the respondent authorities to issue Adhaar card if the petition is found entitled to.
Deeply obliged.
In 2005.
Yes, item 31. Yes. What is the instructions?
So we have filed our affidavit.
What is your stand?
Our stand is that the land was never acquired and the petitioner's land were never acquired and the dike, DTP dike has never changed its position. So
You come to page annexure 8 at page 38. Annexure 8 at page 38. What is the stand with regard to this? Page 38 you are saying, right? This is you are saying that it's a
Lordship.
This page 38 is the document you are saying that it's
Yes,
your
this
line.
This is one document, Lordship, where the government has written to the Judicial and Deputy Commissioner. The circle officer's report is that these lands, that is 8 and 9, belonging to the petitioner.
8 and 9 is yours.
Used. Actually, what happened,
Okay.
Lordship? Since 53, 54, our lands have been used. No doubt without acquisition. But now when it was upgraded, then it was found that my land has been used
for the purpose of upgradation. There are various reports by local inspection through circle officers, even from the respondent number 2, water resource department.
You see, there's another document. Please come to page 61.
Yes, Lordship.
This document is by Executive Engineer, Dibrugarh Water Resource Division, correct?
Yes, Lordship.
Now, come to next page, page 62. Now you see in this 5A, we'll come to other paragraphs later. 5A, you say that firstly, as per so and so, dark number 9 requisition earlier. Then it is not understood if the darks were requisition for construction, which is constructed in the year 1954-55, then why it was not converted to acquisition? That means requisition of the land or use of land of dark number 9 is admitted fact.
Lordship, there, when the survey was done for land acquisition, then we are not informed that these lands are included. At that time, we are given different DAG numbers, and accordingly we have paid the compensation to the affected persons, Lordship.
No.
Now we came to know about the claim, petitioner's claim only after they have written a letter to the Honorable CM.
No. Come to para 2 at page 61. After claim initiated by so and so, new verification was taken. You read this, you find that this land of the petitioner was accused, and therefore you made a proposal. You don't make a proposal for acquisition just for nothing.
Lordship, either the first acquisition was wrong or the second acquisition,
The petitioner is not concerned with that. He has lost his land.
Yes, Lordship, but
Whether your first is wrong or second is right or third is wrong, it's not for the petitioner to make an inquiry. You'll have to tell us.
yes, Lordship. Our stand is that, Lordship, when the first acquisition process was initiated, at that time the petitioner's land was not acquired, Lordship. Neither it was in question.
But you are admitting requisition. Why would you admit requisition in your letter?
Lordship, later on, when surveys were made, then the circle office Dibrugarh has given us that land of the petitioner was is to be acquired. Then, Lordship,
No, you read this letter.
Yes, Lordship.
And then you tell us whether your submissions is correct or not. Is it in tune with your contents of your letter? You come at 2 o'clock because we can't allow you to read here and spend time on the court. You read this letter because in their documents, they are showing that there's rightly or wrongly, there is a survey which shows that the land of the petitioner is included. Now, if you dispute that, this court will not be a proper forum to have that adjudication done. Correct. If you make a survey, all surveys, if it is made by the authorities, you are bound by it. Now, who ordered this survey? Did the petitioner order a survey?
No, Lordship.
Then who ordered this survey? Has to be revenue authorities.
Yes, Lordship.
So you will be bound by it. You can't dispute interstate dispute between the water resources department and the revenue department. Can't be adjudicated here in his writ petition.
Lordship, take up the matter.
If there's a dispute between two authorities, then go to your chief secretary. He is not actively involved in elections. He will hear both of you. Chief secretary is outside election duty. So go to him tomorrow. Right? Mr. Talwar has to stand here.
What happens? The
At 2 o'clock, let him read. Let him
Deputy
read.
Commissioner's affidavit is also there, Lordship.
Let him read.
But
It
that's
was-
self-contradictory. This is interdepartmental.
If
Your
you
Lordship have
if
right
you have
to
an
call.
issue, you go to your chief secretary. You
Absolutely
write
unadmitted
there are so many options open to you. You can write a letter to the vigilance saying that this was not happened and therefore officer XYZ, they granted a survey, made the land of the petitioner to be included in the dike. And this land is lost. So you file a vigilance case before the authorities. Give the names of officers who have done the mischief. Why do you want to save people? You want to save skin of someone.
Last survey was joint survey, Lordship.
This I do not read.
Last survey was
Joint,
joint,
I did not
joint
notice.
survey. Yes, Lordship, Lordship has gone through. I have nothing to submit on this point. However,
Lordship.
Lordship,
And again, Lordship.
would take to his performance.
But, Mr. Sharma,
Yes, Lordship.
please try to understand one issue. It's the prerogative of the government to do whatever it wants. But please try to understand one aspect. You do surveys,
Yes, Lordship.
and in the process, you are creating evidence after evidence. One will say A, second commission will say B, third will say A, B, C, D. Now, let us say that in this case, when you do a resurvey, you get a different opinion. Please tell me then what?
Lordship, when at the first, when the survey was done,
You're not following it, what I'm saying. My statement is that once you are making a survey, the survey report becomes an evidence,
yes, Lordship.
correct? You want to know the provision? Order 26, Rule 10(2). You see this. I'm saying this because writ petition is also a civil proceedings. Order 26, not section. Order 26, Rule 2. 10(2). Report of the commission. What does it say? Report of the commission,
Report and deposition to be evidence.
evidence. Now, this becomes an evidence. Now, let us say if there are two contradictory opinions. Unless you recall the first survey report, second survey report cannot be an evidence because the first evidence runs contrary to the second evidence. And you, as one of the parties, you are bringing on record 2 or 3 different opinions. That's why when I am asking you, then what? Is that if there are 3 or more contradictory opinions in form of a report, but tell us what does the government propose? How will it deal with the matter? You must give a comprehensive answer. Otherwise, what happens is that we, by a judicial order, we permit you to create a evidence, and then we ourselves can't accept it. So therefore, number one, if you're doing it, do it of your own, not by way of a judicial order. And second, please also have a clarity as to what will you do if the opinion expressed in these survey reports are contradictory to each other.
Lordship,
Because otherwise, what would happen is that I am the authority concerned. I want something to be done in a particular manner. The report comes, I say that it's not according to my opinion, so I say second report. Second report comes, I say that it's still not as per my dictates. Third report. So as an authority in position, can I oscillate? Or should I be permitted to oscillate? The deputy commissioner wants, he will do this. The deputy commissioner wants, no, he will do like that. Can the authority in power be permitted to oscillate? And whether that will be in public interest?
Lordship, earlier the reports were given by the circle officer or joint verification.
You put them to jail. First and foremost thing, if a government official gives a false report, what will you do? You arrest him. Have the guts to arrest him before saying that his report is false. If you don't have that guts, can you be permitted to do a fresh inquiry? Unless you find that the report is ex facie false. That is not your stand. Therefore, we can't permit it.
Now the Lordship, the DC have requested the director
No,
of
request
land
is okay. Everybody who comes in power will have their own way of doing things. But can he be permitted to do it? Is there anything on record to say that this report is false? No, you don't take the stand in affidavit. Therefore, you can't permit it. Although you want to do it, but you can't permit it.
We have contradicted the this reports, Lordship.
You see, contradiction means what? Let us say in a writ petition, Mr. Talukdar takes a stand. You file an affidavit as a government, you take a stand. Now, can I postpone the hearing and say that, no, Mr. Talukdar, you file a reply again? After his reply, I say that you again file a reply. And unless you reconcile, we keep on asking the parties to file affidavits. Can we do it? Can I abrogate my work or decision making and leave it to you that you come with a affidavit which is reconcilable between the two, and then we say that in view of the reconciliation made, the petition disposed of. Therefore, your instructions, we can't put an imprimatur to that. We can't permit that to come. Unless you withdraw the first report, you take action against those persons saying that they have done illegally. There's no question of second report. First evidence becomes a report. That's why I'm showing you Article 2. You can't come out with that evidence unless you bring an evidence that is a false evidence. Therefore, now I have completed my part. The issue of evidence, issue of contradictory evidence, the second evidence being contrary to the first evidence cannot be accepted unless the first evidence is false. I don't say that I am authority on the point. I may be wrong. But if I am wrong, please address us and tell us that for this reason your lordship is incorrect. The opinion formed is not correct. Somebody comes to court, says that you have acquired his, taken up his land, you want compensation. Then you say that no, we'll do a inquiry.
No, Lordship. At first, when the initial stage, their land were not in the acquisition list, Lordship. After that, when in 2012, when the resurvey was done, then their land came in the acquisition list. that their land is also included in the dike. That
But why did it happen in the first place? If this land was not taken up, how in the second report, his land was included?
that lordship.
No, you see, I can understand. If you ask any person who is acquainted with PWD, they will tell you, or railways, they will tell you one thing. We learned this in our primary days, that a rail line has a gap in between, because in summer iron will expand and therefore they keep a space for expansion. Now in a dike, do you keep a scope of expansion that in the winter there will be climate change and therefore it will dike will shrink. In rainy days it will eat up water and it may become fat and encroach his land. That can't be. Dike can't change. And there's another reason why it can't change. Because because next to every dike, you will find an inspection road. Without an inspection road, there cannot be a dike. It's an elementary engineering in irrigation. You can ask your department, they'll tell you. So it can't happen that the road will twist and turn with every change of season.
So there is a.
It can't happen. What you are saying is can't happen, just can't happen.
Yes,
You call up, you go outside, you call up your engineering people in your department. Ask them whether the dike has a road or not.
That is why lordship we are contradicting the their stand lordship.
You have not placed anything on record. You don't give coordinates. You don't do anything. You just have to walk in the road with a mobile. You get every coordinate.
Coordinates were given lordship.
It shows that it is not. It shows that his land was not there in the coordinate. Then why do you need the second survey?
Because lordship, in the second survey when in 2012 when the survey was done, at that time lordship their land came up. That their land is included in that.
We are asking you, Mr. Sharma. We are not saying that you are saying what you are saying is false. We are accepting it. But tell us how his land came within the dike.
That lordship.
Then.
So lordship, we have made a joint survey also. And the survey report given in 2012.
No, it's not like these things are not like a sparrow on a tree. That today morning in the morning when you wake up, you see the sparrow in the one branch. And tomorrow morning when you wake up, you don't find the sparrow in the tree. Third day you wake up, you find the sparrow on the other branch of the tree. And then you want to say that we make an inquiry. Why on one day it's sitting in one branch, second day it is sitting in, it's not sitting. Third day it is sitting in the second branch. Is it so easy? You'll have to take a stand that the first survey was wrong. Why it is wrong, you'll have to give reasons. Your documents don't show anything. You shows from one line from any document where you can create a doubt successfully. Read any of your document and create a doubt in the mind of the court. Any document you want, you read it and then tell us that this creates a doubt.
Lordship, the dike has never been changed. So how their land came into later on, how their land came, that is a question, lordship. And further, they have based on land purchase. They have said that they have purchased the land in 71. If the land was purchased in 71, the dike was originally constructed in the year 51. So that cannot be done, lordship, because if it was in the dike, if the land was acquired or constructed before the dike was there, so lordship, that dike cannot be, that dike would be a government dike if the dike is there, lordship.
We just have to show us the, what you call the, cadastral map, the, what is called Van Dyke map. And show us that this was a dark, which is government land. That's all, we just need a Van Dyke map. Show us a survey map, ends the matter.
For the survey map, I have to get the survey map.
You see, all these inquiries are being made without survey map. Deputy Commissioner is the head of the revenue in the district. Does not know how to have a land survey made. Yes, government, what do you have to say? Revenue Department? Your Deputy Commissioner is not trained to.
But I'm told that they are writing it to the DL for
DC.
by the DC. So
What is, why the DC is taking time? The Mandal can sit over the map and do it within an hour.
That report is contradicted by us, Lordship. That circle officer, they have done it, Lordship. So
Now you transform yourself to be a land revenue expert.
No, Lordship.
From
No, Lordship, from the
water
record,
resources, you become a revenue expert.
no, Lordship, from the record, it shows that earlier that their plot of land was not there. Then again in the next survey, it came that their land is there. So we have
Go
already
outside,
released our,
speak to the people and then come back. By which date they are going to do it?
Lordship, that will, they will,
Or they will never wake up.
no, DC have written to them, Lordship, the land and
They will not
DLR,
work.
Lordship.
They will not work. You go
DC
to Guwahati Deputy Commissioner's office, ask the Deputy Commissioner to stand in front of Lat Mandal and have a work done. You will find Lat Mandal is not doing the work.
DC has written to the Director of Land Records and Survey, Lordship. That survey has not been done yet, Lord.
DLR doesn't make survey. You find out the DLR. What is your job?
But in this letter, Lordship,
It's okay.
it is written that
We take it that you are correct. But let us see what does the DLR do? You see, the internet shows that the work of a DLR is that he is in charge of maintenance and updating the land records of the state through the circle officer under the Deputy Commissioner subdivision officers. So he only does that. The DLR doesn't do anything. He is dependent on the land revenue staff for doing his work. That is what the internet says. Either if it's wrong, you ask the government to check it up. This is coming from their website.
But Lordship, the letter that I have.
No, that's okay. That's why we are wanting to understand. Whatever you are saying, we are not saying your statements are incorrect. We are just cross-checking it. I have a bad habit.
This is from the DC, Lordship.
No, that's okay, but I have a bad habit. Correct. So you go to a thief and ask him to catch a thief. This will happen only when there is a turf war. When there is a turf war between two gangs, then you ask one gang to catch the other. So everything we are submitting falls apart.
Lordship, then matter may be adjourned, it may be taken up on Friday, Lordship.
Okay. Let's give them 1 day chance. Mr. L. Talukdar and counsel for the petitioner is present. Ms. S. Babar and government advocate. And Mr. A. Bhattacharjee, standing counsel for the revenue department are present. As for on the prayer made by Mr. C. Sharma and counsel for the Water Resource Department, the matter stands adjourned today. List on 26/4/2024.
Obliged, Lordship.
You see, the difficulty is that I was earlier in that part of the world from where Mr. Talukdar comes. That is the difficulty.
On our lordship.
Okay, 32,
Obliged, Lordship.
26 lordship.
26.
May please your lordship. Your lordship.
Mr. Talukdar, I think you will remember you were there. I just am forgetting the names. There was a cross-examination in Municipal court about persons in the north. And the witness gave the name of the witness in north, house in north, and then said after that north. He said that in the north this was there. Then he said that after that what is in the north? Then the witness said that sir, the boundary of village has come. Huh? The law name I remember, but I was thinking that you were on the other side. No. The name of the lawyer we know. He's the only one who can speak very good Assamese in the civil court. Assamese better than that I have not heard from anyone else. This will give you an idea of whose name I'm referring to. Okay. Yes.
May please your lordship.
Yes.
Lordship,
Mr. Ahmed.
Lordship, here, lordship, I have challenged the order dated 7 September 2021, which is at page number 28.
Just a moment. Just a moment. Okay, yes, you have filed your affidavit?
No, lord, no affidavit has been filed.
This repression deserves to be allowed, but
Not, the term has been already over, my lord.
it's over.
Yes.
Oh.
But lordship, if this order remains lordship, then it will create trouble for me, lordship. I would not be able to contest in the next election. Here, lordship, I was removed from the post of ward member on the ground that, lordship, I was having more than.
We know that. That's why we are asking question. Then we'll have to still proceed with this matter because this will.
Yes, lordship, this will create trouble for me, lordship.
Will create trouble for him.
That is there, my lord, but the order is saying, my lord, she has more than 2 children, my lord.
That's
the
okay,
part.
but the contention of the petitioner is that the children were born before this notification
Yes,
came, therefore it can't be adverse to him.
Yes.
If somebody had 10 children before that.
That has to be proved, my lord. By witness.
Children, age is all known. The age of the children are well known. If you have an inquiry to be made, you can make an inquiry.
Or lordship may refer back to the deputy commissioner, my lord, district
No,
commissioner.
no. He is passed on order, he will not recall that order. So therefore, this order has to be.
Then one
adjudicated.
maybe press inquiry, maybe. Press inquiry may be directed, my lord, because before district commissioner, after going through all the statements, my lord, pass this order, my lord.
You see this order, which is that page?
Lordship, page number
Page 28.
and except 4.
28.
Twenty-eight. third, fourth paragraph maybe
So you read that.
fourth paragraph. And whereas the examination of the gamut of the affair in its entirety has established beyond any doubt that the aforementioned GP ward member Nachima Begum committed fraud and filed fraudulent affidavit with ulterior motive to deceive and misguide, mislead the authority in violation of the Rule 62(1)(a) of the Assam Panchayat Act. In the affidavit, my lord, she wrote as 2, my lord.
No, in the previous third paragraph,
Oh.
the affidavit said that she has 3 children.
3 children.
Now, how many children is there?
4 children.
4 children. But his affidavit
Is
3. Yes.
Then
No, Lordship may kindly come, Lordship may kindly take up my additional affidavit, Lordship, I have filed. Page number 41 is the affidavit. Annex A, page number 40, it starts. May I read the third paragraph, Lordship?
what is the date of this affidavit? 14/11/18.
Yes, Lordship, this was filed, Lordship, along with my election nomination, Lordship. May I read the
Just,
third paragraph?
just a moment. Just a moment. Where is?
Yes, but see.
Yes.
May I read the third paragraph, Lordship, of my affidavit, page number 40?
Yes.
That in connection with my candidature for the above election, I am submitting the information below as required in connection with subsection 1 and subsection 2 of section 111 of the Assam Panchayat Act 1994 as amended up to date. Now, Lordship may kindly skip A, B, C, D, E. Lordship may kindly come to clause number E. I do not have more than 2 living children from single multiple partners as per the meaning of the provision under section 112A of the Assam Panchayat Act 1994. Lordship, here, Lordship, what I had stated, Lordship, I do not have more than 2 living children as per the meaning of that particular section. That particular section, Lordship, if Lordship may kindly. Lordship may kindly take up the Gazette notification dated 19th March 2018.
Yes.
Lordship may kindly come to amended section 111.
Yes.
Second page. Subsection 2, no person shall be elected or co-opted and remain as president, vice president or member of Jila Parishad, Anchalik Panchayat and Gaon Panchayat who has more than 2 living children from a single or multiple partners. Provided that this provision shall not be applicable in respect of those persons who have more than 2 children prior to date of commencement of this act. Here, Lordship, the petitioner is a mother of 4 children. Or all the 4 children, Lordship, were born much prior to that particular date, that is 19/3/2019. The first children, Lordship, was born on 17/12/2007. Second was, Lordship, 21/2/2010. The third one was 27/1/2012, and the last one was, Lordship, 19/9/2007. Therefore, Lordship, this particular section is not applicable in case of the petition. And Lordship,
No. It can't be accepted. The decision of the Supreme Court in PUCL case that the affidavit must give a true disclosure, otherwise the the what you call the candidate will be said to have misled the voters.
But Lordship, while
This-
passing
this,
the,
uh,
while passing the order, Lordship, that impugned order, Lordship, the exercise under section 111 was exercised, Lordship. In a similar case, Lordship, I have annexed one judgment, Lordship, that is at page number 43. Of my additional affidavit. This Asma Bibi, Lordship, was removed from the post of her ward member on the ground that, Lordship, at the time of filing her nomination, there was some discrepancies regarding the issue of her living children. Lordship, may kindly come to paragraph number 6 of that particular judgment, Lordship.
Yes.
Page 46. May I read it, Lordship? After hearing the submission of the learned counsel for the parties, I find that a ward member can be disqualified and or removed from office on the ground of contravention of provision of section 111 of the Assam Panchayat Act 1994 as amended, if he or she had more than 2 living children. However, the said provision admittedly would not be applicable in case of the petitioner, since all her children were born prior to coming into force of the amended provision of the Act. If that be so, there can be no doubt about the fact that the petitioner would not have been removed from office due to contravention of section 111 of Amended Act of 1994. This brings the court to the next issue as to whether any penal action could be initiated against the petitioner for swearing a false affidavit. There is no serious dispute about the fact that the affidavit sworn by the petitioner at the time of submitting her nomination was false. The explanation submitted by the petitioner's counsel is to the effect that nomination paper was filled in by someone else and the writ petitioner had merely put her signature. The said explanation.
You see, long and short of it, come to paragraph 9.
My
That is the direction issued that the authorities may initiate action.
By setting aside that particular order, Lordship.
No, but here they have taken an action. How is that action wrong?
Lordship, they have removed me as because, Lordship, the initial order was passed under section 111. That could not have been passed, Lordship. Section 111 will only be applicable if I am having more than 2 children, Lordship. Nobody has challenged my election in election petition, Lordship.
It's a false affidavit.
Yes,
My lord, you can swear false affidavit. It's not worthy to hold that post of what do you call this?
Ward member.
Ward member. You're not worthy of holding that post. If you can say false statement in an affidavit.
In fact, my lord, order was not passed under 111, my lord. Order was passed under rule 62(1)(a).
62(1)(a), Lordship, it is related to 111. Lordship, may kindly take up the another gazette notification, Lordship, which I have furnished, Lordship. 31st October 2018, the rules. My lord, got it. Insertion of Rule 62. Condition and procedure for disqualification under subsection 2 of section 111 of the Act.
Yes.
Subject to the provision of the Act, at the time of filing of nominations, candidates shall furnish affidavit that he/she has not more than 2 living children from a single or multiple partners. The state government or concerned district authority shall remove any president, vice president, or member of Zilla Parishad, Anchalik Panchayat, and Gaon Panchayat if he or she is having 2 or more than 2 children from a single or multiple partners prior to date of commencement of the Act, that is 19/3/2018, and gives birth to an additional child thereafter.
Where is the provision in the Assam Panchayat Act to disqualify persons for
Section 111.
for filing false affidavits?
I have not found any such rules, Lordship. But, Lordship, there is a rule, Lordship, in the Assam Panchayat Constitution Rules 1955.
Yes.
if we go by the rule 54, Lordship, other matters not provided in these rules.
Election rules.
No, Lordship. The Assam Panchayat Constitution Rules
Constitution rules.
1995.
Paragraph
Rule 54, Lordship.
54.
Other matters not provided in these rules. As regard others matters not provided in the Assam Panchayat Constitution Rules 1955, the matters shall be guided by relevant rules under the Representation of Peoples Act 1951. But Lordship, if Lordship allow me to read the affidavit, that line, Lordship, once again, Lordship.
No, no point reading it again. We have already read it.
Yes, because Lordship, the intention was that Lordship, I had to disclose as to whether I am having more than 2 children in terms of the particular section, that is 111 or not. Otherwise, Lordship, there was no bar for me to participate election after declaring that I am a mother of 4 children, Lordship.
Representation of People's Act. The Representation of the People's Act. Mr. Datta, then we'll have to give a notice to your Advocate General then in this matter.
My lord.
You see, the reason is very simple. 54 says that if other matters are not provided, then you will be guided by Representation of the People's Act. Under the Representation of People's Act, filing of false affidavit is a case of corrupt practice. If it's a corrupt practice, then the election petition is before the High Court. Now by your local act and the Assam Panchayat Act, you can't impose a jurisdiction upon the High Court to take up election disputes with regard to panchayats. You have to create your own mechanism to deal with these. Because now the argument of Mr. Ahmed is that if the procedure is prescribed, you follow that procedure. So 62 may not be an appropriate application. It will be a dispute of corrupt practice. We issue a notice on your Advocate General. Let him address the court on this point. Because you can't, by a local act, bestow jurisdiction on the High Court to take up election disputes of panchayat.
Or better maybe fix another date, my lord. I will go through with my lord. If I can satisfy your lordship this time, my lord.
In the meantime, Lordship, I will also go through the provisions of Representation Act 1951.
Don't worry, this provision is, we are acquainted with these provisions.
Or I'll, my lord, my senior standing counsel, he is also additional Advocate General. He will appear in this matter, my lord. I'll request.
No, no, notice mandatory has to go to the Advocate General, not to the additional may appear before us.
My lord.
But when interpretation is required, the mandatory requirement is to give notice to the Advocate General. He can delegate. He can delegate, there's no issue with that.
My lord.
But on question of law,
My lord.
the court is required to issue a notice on the Advocate General, not on the additional Advocate General. We take up on Monday then?
My lord. My lord.
Okay. One of the issues raised, also the representative, one of the issues raised by Mr. M. Ahmed, counsel for the petitioner, is that in absence of any provision in the Assam Panchayat Act 1994 and rules framed thereunder regarding consequences of Panchayat member filing a false affidavit, under the under rule 54 of the Assam Panchayat within bracket Constitution bracket close rules, 1995, the matters are required to be guided by the Representation of the People's Act, 1951. Stop. Next paragraph, the said issue of law being raised, says Datal and standing also for the Panchayat Department, raised for an adjournment to address the court. List on Monday.
Thank you.
But you also be prepared if that issue is there. Perhaps you'll also you'll be required to amend your writ petition.
Because this is admitted, my lord, that in the affidavit that was.
No, that's
wrong.
okay.
That is.
My lord, may I submit just one line, lordship? Lordship, in the writ petition as well as lordship, my submission is that lordship, I have stated in the affidavit that I do not have more than 2 children in terms of section 111. Section 111.
No, that's okay. We are not hearing, we have left the matter. We are just telling you if this point is to be raised, do it in an appropriate manner.
All right.
Article.
Wait, your lordship. My lord, your lordship order.
Yes.
Order dated 2/11/23.
Yes.
That holds the field now, and nobody says that we have entered into the campus of the Chipsa government civil hospital. And that day, if I remember correctly, the health department, they said they will file an affidavit.
Yes. Who's for health?
My lord, I'm appearing on behalf of Ligugui, my lord.
Yes.
Need some time to file our affidavit, my lord.
Because your lordship has protected the right of the hospital also, and given us.
You are under interim protection.
Yeah. And to be to run our
Yes, yes, we've seen that.
in both sides of the roads, and that is the position now. And they have, if they file a affidavit, my lord, let them.
We extend your interim order. How much time?
2 weeks, my lord.
We give you 4 weeks, but do it by then.
My lord.
Mr. A.C. Buragoy, the senior counsel, assisted by
S Nath,
S.
Sonali Nath.
NATH Nath.
Nath, Leonard, the counsel for the petitioner, is present. Mr.
H. Burwa.
H. Barwa, Leonard, standing also for the health department. Raise for is granted for 4 weeks for the time to file affidavit in opposition in the matter. on behalf of the health department.
Madam.
Who's talking? Interim order
Date 2/11.
passed on 2/11/2023 stands extended till the next date of listing.
Early of next month.
35.
Also, in this matter, we were to file our affidavit already. We have made a draft and we have sent it across. But due to some reasons, we have not received on time. So at least can it be fixed after 1 week? So we'll file. Already our draft is over and we have sent it across.
No, this honorable court wide order dated 13/12/23 directed for producing the status report. And two, Milord,
No, that
previous
report
two
is-
dates, Milord, the status report was there. And the government advocate was supposed to file the affidavit along with the status report. But there is some urgency in the matter.
Where is your FIR, annexure 10? Where is that? Which page?
Yes, Milord, my file, the lordship will find. Page 36, my lord.
How much time you
Then
need?
thereafter, my lord,
How much time do you need?
1 week.
Is there 1 week last chance?
but otherwise, my lord, the issues are very serious in this matter, my lord.
No, in fact, I have the set of the documents which reflects that there are counter charges against the petitioner. Already FIR has been, and his possession, his ownership over the land is
No, that's
also.
okay. He has annexed that
These
FIR
kind-
at page
Look, this is a
44.
Yes. So there are
This
several
looks,
other counter FIRs also
Look,
against
this
him.
is a matter-
And there are several cases which are pending before the Jalukbari police station. A list of which has also been enclosed here. So I have all the detailed report. The thing is that just because I didn't receive the signed.
You file it within a week.
Yes.
Today is next Wednesday. We are fixing it then.
Fine.
You're filing it within you file it within 30th of April.
Yes.
We are fixing it on 3rd of May.
Third, yes.
Look, can it be on 6th, my lord, if not inconvenient?
Sixth,
Third, I have got some difficulty.
both sides are represented. Mr. S. Barber and government advocate undertakes to file an affidavit in opposition in the matter by T04/2024. Accordingly, matter stands adjourned today. Affidavit in reply, if any, be filed prior to the next date of listing. List on 6/5/2024.
36.
And it's the last order.
That's it. We have received the instruction.
Yes.
Short accommodation, please granted to file affidavit also.
What are your instructions? Show me that.
Instruction is. Several public complaints are received by the Deputy Commissioner. And after
I'm just asking you a question. My question is a bit, maybe contents are inappropriate, but excuse me for that. Now let us say we have two good friends sitting side by side to you. Mr. Ahmed and Mr. Prakash are very good friends. Now in connection with this case, they shout. Correct? Both of them shout at each other and create a ruckus. It disturbs public peace and tranquility. I'm just giving a theoretically. Now can the Deputy Commissioner come and say that, no, you stop this High Court? Public peace and tranquility. Now there's a big industry running. The public comes and says, it disturbs peace and tranquility, 144 invoked. Very good. The Data Seal police station creates difficulties. Every time I drive without the helmet, they catch me. Law and order situation. So the police station has to stop public complaints. All illegal activities which are going on, everybody will come together and say this police station is creating a difficulty. We want to do some crime, they are creating difficulty. We want to stop this police station. 144. Can it happen?
that cannot be happened, but
Then
that is agricultural land and there.
no, that's okay. He is running an industry by virtue of some license or some what do you call, some permission from someone. He has all the requisites. Can you stop a business? Under 144. Because till now we have seen police people, they are roaming around every nook and corner. There are every appropriate timing. If you know the timing, then you will also come to know when the police is taking a round on which road. You just have to know the correct time. And if you stand there, you will find the police people, they are doing patrol very promptly in certain areas. Now, from tomorrow, we'll also find Deputy Commissioner doing patrol work. Because 144 he can invoke anyway. Pawn shop, 144 stop. Showroom, 144 stop. There's a big mall somewhere in the Guwahati. He goes there, stop. Where does he get this power under 144 to stop business? And what is the satisfaction recorded in this order about breach of peace and tranquility requiring the big industry to close? Where is that satisfaction? Where is this order page? Which page is the order to stop?
Oh, yes. Info madam, page
85.
30.
35.
85.
85.
It has been stopped on the ground of police on the statute.
Where is this brick clan rules? Where is that? Give me a copy. Brick clean rules. And what is Deputy Commissioner, the authorities in the state are doing? Few days back, Guwahati is a part of history in the world. Second largest polluting city in the world. Now, which industries they have closed down? Which establishment in Guwahati they have closed down for pollution? World's second most polluted city.
In fact, as regard that news, it is supposed to be fake, and our pollution control board also come up clear that there was no such.
No, I was thinking, see, first of all, highest footfall in terms of vehicles would be the state secretariat. So if it is polluting, first of all, start with the secretariat to be stopped. No car will go there. This food will be free of pollution. I was just thinking in terms of her submission. Once it is polluting, you stop the industry. So what happens in the Guwahati city? Highest traffic vehicle is in Dispur. So what do we do?
Going by this policy 144.
144. Section 3. No, you don't have that power. Yes, Mr. Prakash, so
My lord, I am
you are supporting him.
I'm supporting.
We told you that they are friends.
Because I, my lord, I representing some of the public, my lord, and I appear in all the public meetings, my lord. And only 3-4%, my lord, those who are not even residing within the, my lord, 3 kilometers radius, they are raising some objection. So we, my lord, have tried to apprise the deputy commissioner that, my lord, it will rather help the unemployed boys. That will, my lord, create a employment, my lord, scope.
No, we know that. Once we see two of you together.
And my friend also appear along with.
He's also your friend.
He also appear along with.
Because the NOC was obtained from the Gram Panchayat, it was subsequently withdrawn.
Cannot.
After post facto, you can't withdraw it. This where is the provision to withdraw? Which law authorizes consent to be withdrawn?
To verify or ascertain that fact, the PNRD department is not a made party here.
No, because everything you see, we are doubting it because of the fact that if we know how the things are done, it is okay, because otherwise what would happen? You see, this is a,
Basically, what's the problem is that they don't cultivate in their own land. That is their problem. But for them, we should not suffer because our land is there. Because we have come across so many situations in the Nagaon district. If a bricklaying industry is erected in an agricultural land, the adjacent land they get destroyed.
no, but after this NOC being given, the question is, where is the power to withdraw it?
Because at that period of time, no proper public hearing was held. And in our affidavit lordship, we have annexed the
And then who is the authority to do it? If public,
Under the
you see,
supervision
the
of
law
the
must permit that. Now, because tomorrow somebody will come with a case that the excise on shop or off shop was established in road X without my consent. Let us say it's an example. Now, can an establishment which is being operated be closed just because you were not heard?
The hearing meeting was conducted under the supervision of the pollution control board officers itself. They were also present.
No, I'm not doubting their power. But tell us the power. Where do you find that? In which provision of law is that power?
Withdrawal.
To set up, allow an industry to be set up and then withdraw it. Because today is this bricklaying. 10, 20 lakhs, 50 lakhs was spent. Tomorrow it may be 100 crore industry. Let us say tomorrow, fine morning, you wake up and then you find that, okay, at the time when this refinery was established, my grandfather was alive, he was not heard. And therefore this refinery was not set up without proper hearing and my grandfather was not heard.
That 3-2 lordship. They say about public hearing.
No, it's, you read the first part. Restrictions on setting up. It's not restriction after setting up.
And our public hearing
No,
meeting.
I'm telling you, you see, I'm definitely agreed. My grandfather was not heard when this refinery was set up. Hearing on pollution was not even envisaged at that point of time, but now this Air Protection Act 1981 has come. Now I say that my grandfather ought to have been given whether they should run this industry or not. Air pollution control comes, Mr. Barwa's ex-plant has been set up, pollution control board. No, I'm just, in a light on what I'm saying, he was earlier appearing for pollution control board. Now that pollution control board is set up. Now, post facto, I want a hearing. Guwahati refinery has serious objections, it has to stop. Can I do it? Ultimately, these authorities, the deputy commissioner is a creature of law. He must act within the bounds. If you can show us the power, that's well and good. The power can't be shown. Then 144 does not permit him to do it. Let us see 144. This I have read it right now. Let us come to 144. What does it say? That executive magistrate, after taking public opinion, shall form an opinion that there is a public breach of peace for pollution to be caused by the industry. Does it say that 144? The deputy commissioner will hold a public meeting and arrive at a finding that according to the public, there's a public breach of peace because of pollution. And why this deputy commissioner can't advise the government of India for state of Haryana and state of Rajasthan and Uttar Pradesh? The burning of Pareli is causing a very difficult situation in Delhi. You can't breathe. Haryana, this grain shaft is burnt. Why 144 can't be invoked? He could have advised government of India. Yes, Mr. Barua.
Yes.
Deputy Commissioner advised them 144 Pareli burning at Delhi, causing pollution at Delhi, Haryana, Rajasthan and Uttar Pradesh, Punjab. 144, just do it. Arrest these people, stop, save Delhi. Ms. Barua, as a CGC, I have work to do now. Show them the way. Deputy Commissioner in Assam is doing it. We allow this repetition. This can't be saved. If you want to take any action, do it in accordance with law.
Moreover, Lordship, now they are consent to operate, Lordship. That is at phase 78, Lordship.
78.
78, Lordship.
You see-
That period is already over. The validity of the consent to operate, Lordship. Terms and conditions, Lordship.
So that they will
was
take
up
care of.
to
That they
31.
will take care of. But the consent, you see, this consent, according to them, is time limit. Every time it has to be renewed. The authorities don't have power to refuse if everything is okay.
And the liberty may be given to us to approach the pollution.
No. There's no liberty you can't have. You
We could not operate. That is why
can't,
we will not.
you can't be allowed to poke your nose everywhere. You show us from the air protection act that you are empowered to do it. After they give consent, it is their own way of ascertaining if the industry is pollution control, they are doing it or not.
Lordship, in consent to establish also there is a condition, Lordship. The obtaining the consent
For
by
that you don't need, the pollution control board does not need your hearing. It doesn't say that. You show us the scheme of the act and tell us whether public participation is permissible. Pollution Control Board, show us any rules or regulation which says that every time they renew, they will have to have a public participation. We can't create an avenue for you when it's done.
But there is a provision. Because Lordship, if any genuine complaint received. And
Where?
if the in the consent to establish, Lordship, that is at page 76, Lordship.
76,
Yes,
yes.
Lordship. Terms and conditions.
Yes.
Clause 3, Lordship. E, Lordship. Obtaining the consent by misrepresentation or failure to disclose fully all relevant facts. Here, Lordship, that NOC was obtained from the district agriculture officer, not from the circle officer, Lordship, as per the rules, regulations of 2013, Lordship.
So that
So,
will be-
so-
that will
so-
be there,
so
you
pollution
see,
control-
the question of permitting you to participate, where is that?
Lordship, C, if any genuine complaint received, Lordship.
Oh, acha.
Yes, Lordship. Because as per the rules, they have to obtain the NOC, NOC from the Lordship Circle officer. But they have obtained it from the Agriculture Department.
Okay. Heard Mr. J. Amit and counsel for the petitioners. Also heard for revenue will be appearing. You, Mrs. P.R. Mahanto, done a standing also for respond number 1. Mr. S. Barbar and government advocate appearing for respondent numbers 2, 4, and 5. You are appearing, Mrs. S. Barbar for respondent 2, 4, and 5. And Mr. S. Barbar and its standing counsel for respondent number 3 and 6 also, I think.
Yes.
As well as Mr. S. R. Barbar and its standing counsel for respondent number.
Not standing.
Learned counsel for respondent number 8, 10, and 14.
From 10 to 14.
8 and 10 to 14. Okay, 8 and 10 to 14. And Mr. A. K. Purkayasthar and counsel for respondent number 15 and 18.
18 to 24.
15 to
18 to 24.
15 to 24. Okay.
No, 15 and 18 to 24.
Okay. 15 and 18 to 24. Yes. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 14/9/2023 issued by the District Commissioner Nagaon, which page was that?
Page 85.
Prohibiting the petitioner from setting up of its brick kiln until further orders. The said order was passed under the provisions of Section 3 within bracket Roman 2 of the Assam Brick Kiln KLIN Establishment and Regulation Rules, 2013. Next paragraph. In brief, on the case of the petitioners, is that they have set up a brick industry under the name and style of Messrs. N plus sign R Brick Industry at village Raigondia, RAIGONDIA, Bagariguri, BAGARIGURI, Adhaar, under Jajuri, JAJORI, police station in Nagaon district. It is projected that the petitioner has obtained, petitioners have obtained no objection from the concerned authorities as well as including Pollution Control Board, including NOC from the Pollution Control Board. Full stop. Accordingly, the land was developed and chimney was installed. And before operations of the brick industry could commence, the district commissioner, where is this 16/11/22 letter?
Hello, page 80.
80.
Yes, sir.
A little bit. 16/11/2022, directed the circle officer. This will not be deputy commissioner. This will be additional deputy commissioner within bracket revenue, REV. Letter dated 16/11/2022, directed the circle officer, Nagaon Southern Revenue Circle, to conduct a public hearing regarding the brick industry of the petitioner by directing the meeting to be videographed and to be held after giving wide publicity. Full stop. It is projected that a public hearing took place on 1/12/2022 and the proceedings were submitted to the District Commissioner, Nagaon, by letter dated 9/12/2022. Full stop. As nothing happened, the petitioner had approached this court by filing WPC 1938 of 2023. And this court by order dated 4/4/2023 disposed of the writ petition. In view of consent of the parties by directing the Deputy Commissioner within bracket Revenue Branch bracket close Nagaon to take a decision with regard to public hearing held on 1/12/2022 and communicate the decision to the petitioner within 1 month. By further providing that prior to taking of the decision, the authorities will give an opportunity of hearing to the petitioner if they were not heard during public hearing. Full stop. Thereafter, by order dated 14/9/2023, the District Commissioner, Nagaon, based on the report of the public hearing held on 1/12/2022, prohibited the setting up of the bricklaying of the petitioner under the name and style of Messrs. N+R plus his sign plus sign are bricklaying until further orders under section 3 within bracket Roman 2 of the Assam Bricklaying Establishment and Regulation Rules for 2013. But Mr. Ahmed, your affidavits are interesting. Dusty service, you are writing DUSTY. Dusty service. This 8 and 10 to 14 is Mr. Prakash. Mr. Barua.
8 not
8 and 10 to 14.
8, 10, 8, then 10 to 14.
You're there.
Yes.
Okay. The respondent numbers 8 and 10 to 14. I filed the affidavit in opposition. And it is And it is stated that the petitioner has obtained land utilization certificate from the district agriculture officer, but not from the concerned circle officer of the concerned revenue circle, which is in violation of the 2013 rules. It is also stated that the public were not informed, local public were not informed about granting of NOC by the secretary, Rai Dongia, Raidungia. Rai Gondia or Dongia? Dongia. Okay, then the first spelling is wrong, I think. Raidungia, Gaon Panchayat. And therefore complaints were made. And subsequently the NOC was cancelled, which was intimated to the office of the district commissioner on 13/9/2021, as well as to the inspector of factories, by letter dated 6/4/2022. It is also stated that in the periphery of the area, there are residents within 200-meter aerial distance from the brick industry, and a school and a place of worship are also situated within 400-meter aerial distance of the said industry. And at about 1 kilometer and 2 schools are also located within 1 and 1.2 kilometer aerial distance from the said brick industry. Accordingly, it is stated that in the public meeting, apprehensions were or apprehensions of objections of the people were recorded. It is also stated that although the consent to establish was issued on 12/4/2022 and 16/10/2022 by the Pollution Control Board, but the brick industry had started to function prior to that. Most of the learned counsel for the said respondents has also submitted that there are agricultural land adjoining the brick industry, and there is every likelihood that once the operation of the brick industry starts or commences, the agricultural land in the vicinity of the said brick industry would be rendered useless for agricultural purpose. Next paragraph. No, not that's right. You submitted already. It is also submitted that as per the terms and conditions of the consent to operate issued by the Pollution Control Board. Where was that page?
Consent to operate page 78.
78. Seventy-eight. No, that conditions you showed us.
That is 76, the consent to establish.
76.
Yes.
Referring to the condition number 3 of the consent to establish date 12/4/2022 issued by the Pollution Control Board, Assam, it is submitted that the said consent to establish is subject to modification or suspension either in whole or in part, and is also capable of being withdrawn by the Pollution Control Board. For violation of any terms and condition of the consent to establish, for obtaining the consent by misrepresentation or failure to disclose fully all relevant facts, or in case of any genuine complaint received. Accordingly, it is submitted that there are the petitioners have violated the terms and conditions of the consent to establish, and they have obtained consent by misrepresentation by obtaining NOC from the agricultural office instead of the circle office. Accordingly, it is submitted that even otherwise, on a genuine complaint, the consent to establish can still be revoked. Next paragraph. The learned counsel for respondent numbers 15 and 18 to 24 has submitted in favor of the petitioner and it is submitted that the persons who are objecting to the setting up of brick industry do not reside within the periphery of the said brick industry, and therefore they are rank outsiders, and therefore do not have a locus standi to raise any objection. Next paragraph. The learned government advocate has produced a copy of instructions dated 18/4/2024 provided by the District Commissioner Nagaon wherein it is disclosed that the direction to the circle officer to stop operation of the brick lane to avoid untoward incident was done under powers through powers vested under section 144 CRPC, though not mentioned explicitly. And it is projected that the excessive power under section 144 CRPC was implied. It is also something that several public complaints were received. The public complaints, not several, public complaints were received from the President, Public Secretary of Rai Dungia, RAIDUNGIA, Anchalik students, after S apostrophe, union within bracket regional, IVT, Sarat Chandra Bhuya, SART, Sarat Chandra Bhuya, and 16 others. And Prafulda Rajpura, resident of BUR, next word Raidungia, RAIDUNGIA, against setting up of the brick kiln. Next one. This Mr. Barwa, what is this Assam pollution control? There, what is the rules?
The brick kiln?
No, Assam, this public pollution control board, which is the rule?
Air Act of 82.
No, this is under some rule.
Rule. Environment concentrated under section 21
Environment
of
Protection
Air Prevention
Act.
Control Pollution Act 1981. Page 76.
76.
First beginning, my lord. Concentrated city under section 21 of the Air Prevention of Control Pollution Act 1981.
Okay. Next, the object clearly stated that nothing is produced before the court to show that under the provisions of air within bracket prevention and control of pollution bracket act, a district commissioner who is also the collector and district magistrate in the state of Assam is empowered to stop operation of an industry which has been set up on the strength of consent to establish and consent to operate issued by the Pollution Control Board from Assam. Full stop. The provision of section 144 CRPC also does not contain any provision from which it can be gathered that an industry set up on the strength of due permissions can be prohibited from functioning under powers vested under section 144 CRPC. So the order dated 14/9/2023 does not disclose the satisfaction of the district commissioner that the said industry was a danger to human life, health or safety, or that its operation could cause disturbance of public peace and tranquility. Therefore, the conditions precedent for exercise of jurisdiction under section 144 CRPC is not found available and or disclosed from the impugn order. Therefore, the court is inclined to hold that the order dated 14/9/2023 under memo number capital NRP 18/2015 issued by the District Commissioner Nagaon is expressly unsustainable. Next para. The issues raised by the Learned Counsel for the respondent numbers 8 and 10 to 14, right?
Not correct.
No, 10 to 14 are basically issues which are to be visited by the Pollution Control Board Assam to examine if the consent to operate was obtained by deceitful in a deceitful manner. Stop. The said authority has not been, the said authority was never called upon to decide the validity of, to revisit its consent to establish and consent to operate. Stop. The power vested with the Pollution Control Board Assam cannot be exercised by the District Commissioner to have an inquiry made as to the set to documents issued by the Pollution Control Board Assam. Therefore, if anyone has a genuine grievance against the setting up of the industry, inquiry, if any, can only be made by the Pollution Control Board Assam and no other authority, unless such authority is expressly vested on such authority by any provisions of law. Stop. No authority can assume power which is not vested with it. So therefore, the District Commissioner, Nagaon, having not been vested with any express or implied authority to inquire into pollution by any industry, cannot be permitted to venture to make an inquiry to make such an inquiry. It must be left only to the wisdom of the Pollution Control Board Assam, insofar as the state of Assam is concerned. Full stop. The court has not been shown any provision of law which permits public participation in an inquiry to be made by the Pollution Control Board. Therefore, therefore it expressly appears that although complaints can be made by anybody concerned against an industry to be polluting, but in the absence of rules permitting public to participate in the inquiry, the authorities in the Pollution Control Board are not unless allowed by provision of law cannot be directed to permit cannot be directed to hold an inquiry in with participation from public. First of this observation is made as because no provision of law has been shown to the court permitting public participation in such inquiry made by the Public Pollution Control Board. First of, therefore, it is clarified that if there is any law permitting public participation in the inquiry, we said legal provision shall prevail over the observation made by this court. Next paragraph. Unless the circumstances, is discussed above, taking note of the fact that next paragraph, to cut that out. From the impugn order dated 14/9/2023, it appears that the District Commissioner Nagaon had invoked the provisions of Section 3 within bracket Roman 2 of the Assam Black Green Establishment and Regulation Rules, 2013. A copy of this said regulation has been produced by Mr. J. Ahmed, counsel for the petitioner. Full stop. Rule 3 of the set to 13 rules, 2013 rules is extracted below. Full stop. The said rules do not envisage any inquiry by the district commissioner. Rather, under Rule 3 within bracket 2, public hearing was required to be conducted in the concerned Gaon Panchayats. In this Panchayat Act, can anybody tell us is a deputy commissioner member by default of the Gaon Panchayat? On a query of the court, next one, on the query of the court, the counsel appearing for the respective parties could not show any provision of law in the Assam Panchayat Act, 1994, which makes the district commissioner of a district to be a member of the Panchayat Raj institutions. Full stop. Therefore, expressly it appears that the district commissioner of a district in the state of Assam cannot be empowered, cannot be said to be empowered to take any decision within the scope of within the scope and purview of Rule 3 within bracket 2 of the Assam Brick Kilns Establishment and Regulation Rules, 2013. Full stop. It appears that to overcome the bar created by Rule 3 within bracket 2 of the 2013 rules, the District Commissioner Nagaon, in the instructions dated 18/4/2024, provided to the Runner Government Advocate, has altered its stand by saying that the power under the exercise of power under section 144 CRPC can be presumed. Stop. The District Commissioner Nagaon cannot be permitted to oscillate and to change a stand which is contrary to the contents of the impugn order dated 14/9/2023. Full stop. This, although no adverse steps is being ordered, but it expressly appears that a false stand is sought to be taken by the District Commissioner Nagaon, which amounts to interference with the administration of justice by this court. Full stop. We take an exception, though we take an exception to the change of stand taken in the communication dated 18/4/2024, but we stop at that. Stop. The said instructions dated 18/4/2024 addressed to the Government Advocate by the District Commissioner Nagaon is retained as a part of record. Stop. Therefore, the District Commissioner Nagaon cannot be said to have been vested with any power or authority either under section 144 CRPC or under Rule 3 within bracket Roman 2 of the 2013 rules to exercise jurisdiction to stop operation of the brick industry of the petitioner. Therefore, this, in view of the discussions about on this reparation stands allowed. The impugn order passed by the District Commissioner Nagaon under memo number NRP 18 of the 2015 dated 14/9/2023 is set aside and quashed, being without jurisdiction. Next para. The disposal of this repetition shall not be a bar for the Pollution Control Board Assam to make any inquiry as may be deemed fit and proper in respect of the brick industry sought to be established by the petitioner under the name and style of Mrs. N+R Brick Kiln, as they may be so authorized in accordance with law. We give the Pollution Control Board power to revisit it, but this Deputy Commissioner's action is quashed.
Petitioner, to operate.
You do it, we are not saying anything. That order is quashed. We can't allow you to operate because the High Court does not have power to allow you to operate. Power to operate is only by the.
Only operate order is there.
No.
Power.
We quash that. We can't permit you to operate. I am not the Pollution Control Board.
But control board already granted me to
That's
operate.
okay. We do whatever.
Only
we
operate.
This brick clean establishment rules 2013, even though it is readily available in the net, but this is not a gazette notification. There is no statute as such. Only this is a guideline which the board is following also 2013. So even though we are strictly following as per the guidelines that we have set for our own.
Let's produce a copy of that. Just set that language. You see that? in respect of the said 2013 rules, Mr. S. Burwat and Counsel for the Pollution Control Board, as well as the government advocate, learned government advocate has submitted that as per his instructions, the 2013 rules has not been notified in the official gazette. First of all, however, the said rules are being followed in by way of accepting it as a guideline. Let's stop it. Just add this somewhere. This is.
Only one observation. There is no buyer who operates.
No, we are not called upon to do it. You see, that gives a license. License.
Only we have the already operate order is there.
Item 37.
Okay, you have introduced? Okay, we issue notice then. You are Sanjay Sharma, petition person? Yes. Mr. Sanjay Sharma, heard Mr. Sanjay Sharma run a petitioner in person. Heard Mr. Sanjay Sharma, petitioner in person. Issue notice on this application for appointment of arbitrator under section 11 within bracket 6 of the Arbitration and Conciliation Act of 1996. Mr. S.S. Roy Leonard, CGC, accepts notice on behalf of all the respondents. Full stop. Notice is made returnable. 3 weeks would be okay. This is the amount. Returnable. Give a date after 3 weeks. Actually, in opposition, if any be filed at least 1 day prior to this next date of listing, by providing copy thereof to the petitioner through his email address. Please give him your email address.
Your Lordship, please give me a specific date after 3 weeks.
We'll give a
First
date.
week of June. Deal.
Give a date.
Lordship, let it be on first week of June because in the last part I will not be available in May. First week of June.
3rd of June.
3rd of June.
You give your email
Lordship,
address.
I will,
You exchange your email address.
Only thing is that, Lordship, there is a panel of arbitrator in terms of the agreement, Lordship, contract agreement.
Under the new rules,
Lordship.
under the amended act,
Lordship.
now you're aware of the
Lordship.
12.5.
12.5. Lordship.
So now there's a statutory provision.
Your Lordship, they have already appointed one arbitrator. And in reply to that, I have given reply that we have already moved an application for appointment of independent arbitrator. And after giving my reply, the appointed arbitrator has requested the chief engineer to cancel his resignation, and this all is there.
It's okay, they'll respond to it.
Your Lordship, one thing is there, sir. There was an application for stay on proposed recovery on my restraint post, and the department has already floated.
That we can't do it under 111 we don't have that authority to do it. So that you'll have
Separate
to.
application has been under section 29 rule first and second is enclosed here in petition.
As well, order 39 rule 1. 2 CPC.
No, we can't do it. Where is that, letter?
That was not an ex law.
Oh, no, you said, no, 31, 39, we don't have power. This is not a suit. That's right. After that, we write, at this stage, the petitioner in person has referred to an application which is attached with this arbitration petition, which is filed under order 39, rules 1 and 2 CPC. whereby prayer is made for restraining the respondent authorities from recovery of any amount under the risk and cost from the petitioner. Full stop. In connection with the said application under Order 39, Rule 1 and 2, CPC, comma, the court is of the considered opinion that that such an application can only be accompanied to a suit which is expressly contained in the provisions of Order 39.
Rule 1 and 2.
The 39 Rule 1. Is always XXX. XXX I X 39. The content text of Order 39 Rule 1 and Order 39 Rule 2 of the CPC. Full stop. As the Arbitration and Conciliation Act is a complete code in itself, comma, the petitioner person may be well advised as to the recourse required to be taken for such prayer. Full stop. According to this, the accompanying unnumbered application and Order 39 to Rule 1 and 2, which is yet to be numbered, is held to be non-est in accordance with not non-est in law. And therefore the registry need not register the same. First of this, the observations made by this court in connection with the application under Order 39 Rule 1 and 2 CPC shall not be a bar for the petitioning person to avail any other remedy that may be available to him in accordance with it. This we are closing.
Item 38.
In this case, there is a deal, bill was dismissed on the ground of delay. Lordship, we have sent for otherwise comments, we require some other time.
Okay, the interim order is sanctioned.
Yes, sir.
How much time?
3 weeks.
3 weeks, okay. Both sides are represented. On the prayer made by Mr. S.C. Kyalan as standing counsel for the CGST, the matter stands adjourned today. To stop. The interim order passed on
First of April, I think.
on 3/4/2024, right?
My lord.
3/4
Yes, sir.
3/4/2024 stands accepted to the next policy.
39.
Yes.
Yes, here lordship, the registration was cancelled for non-filing of return. Thereafter, he preferred appeal. Appeal was dismissed. The estimate come to page 29. Lordship.
No, but the dismissal is barred by limitation.
No, dismissal has been time for non-filing of return within 6 months. But thereafter, he preferred appeal. The appeal was time barred.
Yes, that's what we are saying under 112. Yes,
Yes,
it's time barred. Yes.
Page 29, Lordship. Because in many cases, Lordship, this honorable court passed order for restoration of the registration. But here, Lordship, page 29.
29, yes.
Hence, the appeal cannot be taken up on merit, which are beyond scope of power of the appellate authority available within the statute. That the same is barred by limitation. I find reliance on Singh Sancho, where the apex court in their judgment observed that the commissioner appeal is not vested with the power to condone the delay beyond permissible period under statute. Further, in another case, same law was laid down. The case come up with different benches. So this is the difficulty before the honorable court to overcome, because under section 107, 90 days plus 1 month. Beyond that, it cannot be confirmed. This is the difficulty.
But the High Court is extending the time.
No, Lordship, but here, Lordship, please to see page section 107.
107. GST Act.
Yes, Lord.
GST Act.
Section 107, subclause 4. Subclause 4 says that the appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be.
You're reading which provision?
1074.
4. Yes.
The appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allowed to be presented within further period of 1 month. The same provision is Central Excise.
Where is your memo appeal? Where is that?
Yes.
Page 21, is that?
Yes, madam.
Where is your explanation about this 14 months delay?
Yes, madam.
Where is the explanation?
So Lordship, kindly see page number 27, madam.
27. 7.
Yes, madam. Running page, madam.
Yes, 27.
Para 3, madam.
Para 3, yes.
After the 3 lines, madam. The appellant stated that
No, but you see, Mr. Kyal, let us say that his registration is revoked. He can apply for a fresh registration.
Yes, that proposal on last occasion, I gave this proposal to the council. He can apply and will facilitate to give the indemnity shortest period.
No, you see this paragraph 3, even if it is correct, is very vague.
It was his contention.
No, that's what I'm saying. I'm telling you. The ground taken is very vague.
Will,
my lord, due to the nationwide lockdown, as well as my lord, he was the layman, he do not know how to file the GST returns in the online also, my lord.
No, those things you see.
At that time, my lord, due to the nationwide lockdown, he was totally broken, my lord. So therefore, he was unable to file his returns.
No, no,
I-
you see, we may have sympathy with the petitioner, but
Yes,
the,
ma'am.
Mr. Sharma,
Yes,
the problem is that 14 months delay will have to show some reason to allow it.
yes,
When the statute says
yes, ma'am.
a particular limitation, then you say, you see, and when you come to the Arbitration and Conciliation Act, these
Yes,
courts
I-
have interpreted that the power to condone is not there,
Yes, ma'am.
correct?
Yes, ma'am.
So these interpretations have come in many other laws.
Yes, ma'am.
So therefore, insofar as limitation is concerned, where section 5
Limitation.
is not available,
Yeah.
we have to have some convincing cause for condonation of delay. Otherwise, you apply for a fresh one and then
I
go ahead.
Lordship, I will apply for, as per your lordship direction, but my lord, I have only one simple submission, my lord. Already this similar issue, similar facts, our honorable Guwahati High Court has disclosed it.
Sure.
In that case, this question was not raised.
Already, if the lordship satisfied, lordship.
Let us see. There is your statement in this reparation that you are ready and willing to pay the arrear tax, interest and all.
Yes, my lord, I have already paid. I have already paid. Now, lordship, kindly for a moment, lordship.
Where is the statement in your repetition?
Lordship, I have annexed the payment also, my lord. Lordship, kindly see annexer 5, page number 19, my lord, and 20. With lordship, I am not. Till up to date, my lord. That is 19/9/2023, my lord, annexers 5 and 6. And I have categorically mentioned in my writ petition, lordship, in paragraph number 6, my lord.
Can you get information specific on that?
Lordship, I talked to the officer also. They said this is the problem.
No, because if he has no dues to be done, that
No.
means
Here, Lordship, this is a self-assessment procedure. His registration was cancelled for non-filing of the return, unless he files a return. And we can, only after that we can come to a conclusion how much tax is due.
so you are saying that the returns were not filed along with this.
That, Lordship, on the ground of dismissal of the appeal, I talked to the appellate authority. They said that this is the difficulty, we cannot condone the delay beyond this period.
No, that's not the question we are asking. The query of the court is that if otherwise you find from the department that the GSTR return has been filed. And on such filing, you have not reopened the case or there's no other tax found due. At least that much inquiry you can.
That I can obtain, but Lordship, the second difficulty, whether appeal authority can found on the delay beyond the.
No, they may not, but we can still issue a direction.
Lordship, probably in view of the judgment of the Honorable Supreme Court. That was in view of the judgment of the Supreme Court, the two judgments referred by the appeal authority.
Which one?
Page 29, Lordship.
Seeing enterprise, my lord.
And thereafter, our High Court also passed an order division bench. When the statute doesn't provide for condonation of delay.
That's so Smith claim.
Yes, Singh Enterprise and yes, both the judge.
Singh Enterprise.
So Lordship, relying on this two judgment, if Lordship permits Lordship, I will relying another High Court judgment that High Court relied 9 judges bench judgment of the Constitution. So this is the same facts, my lord, in the GST case in Mafatlal. So Lordship, if it is assist me, then Lordship will consider my prayer, my lord.
GlaxoSmithKline paragraph has been quoted here, page 29.
Because my lord, they are the quasi judicial authority. They cannot. Yes.
No, this is a direction which can't be issued by this court. This would be, this would be contrary to the to several judgments of the Supreme Court. Here it says that if required, the central government and the state government may suitably amend the rules. Amendment
that is
direction for the High Court to issue a mandamus to the state legislature and the parliament to amend the rules.
Yes, my lord is absolutely right. I don't
No.
that matter. But I just point out that the act or the statute provides the limitation period. And
No, this you see that would be very contrary to the
Yes,
you see
I
the
rely on the death-
Mafatlal. No, since you have raised this issue of Mafatlal, you see Mafatlal says what?
Yes, ma'am.
Yes, that is correct, my lord. That is absolutely correct. But my lord, if I not paid the dues, I have not paid. But yes, my lord is absolutely. But my lord, I have humbly small submission because my lord, that the GST Act in the Act does not stated that I have not paid the salary. So I have only, yes, my lord. I have come from the, yes, my lord is absolutely correct. I have not come to the court at the right time, my lord.
This is the.
Yes, it is, that is the absolutely right. But my lord, they have quasi judicial authority. They cannot act as a court, man. In that judgment. Yes, my lord. So my lord, your lordship has exclusive power to exercise extraordinary jurisdiction, my lord. That is the absolutely right, but my lord, yes, my lord. Yes, my lord. My lord. But other high court also, when the matter was to other high court similar matter, my lord, they have to revive their my lord.
Not. I'll find out. Let me.
Yes, sir, my lord.
Lordship.
Assessment.
No, assessment you cannot make, Lordship. This is a self-assessment procedure. No, unless they file returns and submit their details, what business they undertaken during this period. It will be difficult for department to come to a conclusion how much tax is due or how much tax they have to. Next week.
Monday, Lordship.
On 2nd of May, Lordship. Then first Lordship. ঠিক আছে ঠিক আছে
Briefly obliged, my lord.
Lordship.
53.
Lordship, my lord, Lordship, Mr. KP Patel, he is suffering for fever, my lord. So he could not come to the court today also. So maybe next week or
Lordship.
Lordship. Given the like after 2 weeks, then Lordship. 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 On 8, 9, Lordship. 9 will be Thursday. Right. Okay.
There is item number 9, my lord. Lordship. Block companies. I have got a list, but kindly keep it on Friday and I'll place it. Friday. Well, I have got the numbers, I have got the numbers. I have got the numbers, I'll place it.